1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 10, 9, 8, 7, 6, 5, 4, 3, 2, 1. Low, 1, 2, 3. See?
Hello. Hello and welcome everyone. We are almost on time with our event. We are so happy to see you at this international conference. I think with not much further ado, I think we should start. So we have right here on the stage our first panel with the welcome remarks. Yeah, and I would like to salute our speakers. And maybe we can start with Jorda. If you want to start, then I think we can give it a go. Wishing everyone a pleasant and useful time spending, and welcome everyone once more. Thank you. We're very excited to having you here. Have a good day, everyone.
Buenos días a todos.
Good morning, everybody. My name's Jordan, and I will be here throughout the whole day. First of all, I would like to thank all those of you who are here with us today, both here in person or online. Before we start, I would like to just share some ideas with you. The event today is going to be recorded. A video of the event will be posted on Plena Inclusión and Disabilities channel. All the personal information that we requested will only be used to inform about the project results. And now it's time to start. Today we're going to be talking about people with disability and access to justice. All the people here today to talk about this topic, and the fact that we have over 400 people online, show how important it is to talk about this topic. And it's not just me saying so because I know of it, but also because I went through it. And to do so, I'd like to invite Steven and Enrique Galvan. Enrique Galvan is the director of Plena Inclusión Spain. He's a psychologist and teacher. He has been working around disability for over 30 years. Besides that, Enrique is also involved actively in the third sector platforms. And Stephen is the director of the Validity Foundation. He studied law in the University of London, and he used to work in the experiential program for young people with issues with law. And Enrique and Stephen, thank you very much for being with us in this welcoming event, an opening event. Thank you. First of all, I'd like to ask Stephen, why do you think it is important to talk about access to justice for people with disabilities? And how do you think the project we are presenting today is going to help advance these issues? Thank you.
Muchas gracias, Steven.
Thank you, Stephen. And Enrique? Oh, sorry. Stephen, go ahead.
So, thank you very much, Jorda, for the kind introduction. It's an honor and a privilege to be with you here today, with colleagues from Plena Inclusión and from the consortium of the Enable project. This project at its core is about improving the access to justice of persons with disabilities, but even more specifically about improving the fair trial rights of suspects and defendants in the criminal justice space. People who are defendants or suspects are not the most popular actors. They're not popular in our societies. They are not popular in public debate. And indeed, when it comes to persons with intellectual and psychosocial disabilities, when they find themselves a suspect in criminal proceedings, it is often the case that they are denied equality and equal access to justice. Now, since the adoption of the Convention on the Rights of Persons with Disabilities, it's clear that our justice systems need to adapt. There is a general principle of equality before the law, and the right to a defense when we are held as a suspect of crime. But all too often, our justice systems deny these equal participation rights for defendants with intellectual or psychosocial disabilities. There's a number of reasons for that, one of which are very old stereotypes that our justice systems and our societies have about people with intellectual and psychosocial disabilities. In the case of persons with intellectual disabilities, often there are incorrect assumptions about their capacity to stand trial, about their capacity to plead, and about their capacity even to instruct lawyers in their own defense. In respect of persons with psychosocial disabilities, many of these barriers are similar, but there are also deeply ingrained stigmas concerning persons with psychosocial disabilities who are often seen as a danger to themselves or others. Now, these stigmas and these historical barriers in our justice systems have a very profound effect in many, many cases. In the Enable project, we have heard from people with intellectual and psychosocial disabilities who have been denied the right to a fair trial. They have been denied the right to instruct lawyers. And often this results in their placement, indeed, in parallel systems, outside of the protections of the general justice system. And this in itself can result in very, very serious and profound consequences for the individuals. Being denied the right to equality before the law can result in persons with intellectual or psychosocial disabilities being institutionalized. In some cases, they can be institutionalized for longer than persons without disabilities who have stood trial. Now, our justice systems have an obligation since the adoption of the CRPD to take specific measures to ensure equality before the law. This means adapting procedures within the justice system, from how police take testimonies from persons with disabilities, through to how the trial plays out in the courtroom. Many of these are not very complex, but they do require will. They also require the active involvement of speech and language therapists, people who know the person concerned, and indeed lawyers themselves who need to adapt and ensure that they are offering an adequate defense. Now, the Enable project is trying to improve this by giving tips to judges, tips to lawyers, and tips more widely to the justice system. It says it's no longer acceptable to deny the right to a fair trial to persons with disabilities. And indeed, although this conference today and the project cannot resolve all of the big questions, some of them such are the insanity defense, we do hope that today, however, we will begin opening those discussions. I'm particularly delighted to know there are many judges present today, both in person and online, as well as legal practitioners. Together, I think we can learn from the Spanish experience, which is why we are hosted today, where there are some really positive developments about improving communication, for example, with suspects of crime, about making procedural accommodations available, and our justice and court systems more accessible. I think as human rights lawyers, we need to continue calling for those within our own profession to take more seriously the right to provide equal access to justice for all. And hopefully you won't hear too much from me today, because more importantly than all, I think, is that we have experts by experience who have gone through the justice systems themselves and indeed are now ready to make recommendations that I think we all need to follow. So it just remains for me to say thank you very much again for the very warm introduction, I very much welcome all of the participants here today in person in Madrid and online, and I'm very much looking forward to some very fruitful discussions going forward today. Thank you very much.
Muchas gracias.
Thank you, Stephen. Enrique, I'd like to ask you, do you think that the situation of people with disabilities in justice has improved in the recent years?
La pregunta y me gustaría antes de
Thank you, Yoda, for your question. And before I answer, I'd like to say hello to Steve and the whole team from the Validity Foundation and all those who have been involved in the project, coming from 8 different countries, and it is having impact in many other countries. Just a few minutes ago, I saw some people who are coming from Chile and people who are connected and coming online from many different parts of the world. And we also have CERMI, which is the organization that represents people with disabilities and their families here in Spain. And it all has a lot to do with your question, Yoda, because we have done a very far-reaching pilot project. It's very important. And we have to congratulate Natalia Perez, because from Plena Inclusión, she guided it and led it in a wonderful way. So thank you very much, and I would like to thank all the team that made it possible. And why am I saying it's very far-reaching? Well, because in the ecosystems, now that ecology is so important, they say that when in an environment you can see butterflies, it means it is a place that's in balance from an ecological perspective. And there are places, as Steve mentioned, that due to stigma and cultural difficulties and historical barriers, some of these places are not ecologically humane or human. And including in the vision of people with mental disability in an area such as justice, is a proof of concept. I wonder how you're going to sign that, but it is proof that it's a system that's valid for everybody. So we are not talking about a project that's linked to people with mental disabilities or developmental disability, people with cerebral palsy. We're not just talking about people who have mental health issues. We're talking about the quality, the democratic quality of a country. A country that allows itself to exclude from justice an important part of its society is a democracy that's still to be accomplished. It is a space in which human rights are not being respected. And Europe has a tendency to think that it has a deployment of human rights way beyond the rest of the world. And I believe that we should probably look at ourselves. We should probably realize that there are many spaces that are being systematically and constantly broken for many people. You know that Plena Inclusión, I don't know how long it's been working, but probably 35 or 40 years working in Spanish jails, Spanish prisons. And we can systematically see how many people that are imprisoned and they shouldn't be there. And throughout the whole process, they have not taken into account the disability variable around all these topics, all these things that Stephen was saying: lack of accessibility, lack of information, and lack of awareness. So have we improved? Why am I saying all this? Because if I say we have improved, it seems that things are going fine, but I could say that we are improving, but things are still looking bad. And from that, through that glass, we can say that many things have been done. And in Spain, we have people here in the room and also online. We have people who are much wiser and experts that have been involved in the legal area for many years. They've been working around these topics and they have achieved very important successes. Just to summarize some of these big milestones. A short time ago, the Spanish Constitution was changed, and it is the first social modification in which people with disabilities were included. They also included their organizations, and they paid special attention to boys, girls, and women. That's a milestone that we reached thanks to the work of CERMI and their organizations, in which we have been able to generate this consensus that should move Spain towards a much more or much fairer space. And we have also modified some regulations, and from Plena Inclusión, well, they worked a lot around right to vote with a program that's called My Vote Counts. And we are trying to push other countries so they can achieve the same objective. We have also been able to get rid of these forced restraints that were part of our legal system, and it's a violent act on people without their consent. And of course, we have improved with the modification A/2021, in which there's a change of paradigm around elements as important for the capacity of people, such as the ability or their ability to make decisions or their capacity to make decisions, to be able to get involved in their own legal business. And also the role of the facilitator, the legal facilitator, and other elements to get rid of issues such as easy reading documents for notary publics, for example. So we have done things that are important. But given that the roots, the culture itself, still hasn't moved, we have to deepen and make sure that these concepts are rooted, so they're not just anecdotal in a world that's not changing. We don't want to get headlines in a space that's still unfair. And this is the end. And there's a thinker, Spanish thinker, a philosopher. His name is Gomá, Javier Gomá. And he says that the biggest invention in the 20th century was the new concept of dignity. Because dignity, understood in the 20th century, allows the rights of one person, just one person, from their dignity, to be as strong, those rights are as strong as the interest of a majority. Even if a majority of people want something, or some other thing, if there are rights and there's the dignity of one person, you cannot step off the dignity of that one person. I think we're in that space. So in order to respect one, all of society is going to get better. I think that's the path to walk, Jordan. Thank you.
Muchas gracias a los.
Thank you both. Thank you both for your answers. And after this welcome, we're going to give the floor to the next panel, which is Voices in Justice. We're going to know the experience of people with disabilities in Bulgaria's and Spanish justice systems. Thank you.
Donde tú quieras. Vale. Buenos días a todos y todas.
Good morning, everybody. My name is Gregorio Saravia from the Spanish Committee of Representatives of Persons with Disabilities, and I would like to thank Plena Inclusión for their invitation to helping me be part of the panel on this conference on access to justice with a roundtable that, as Yoda mentioned, is linked to the experience of people with disabilities and how to interact in their experiences interacting with the criminal justice systems. And we have the experience of an ex-defendant, former defendant, and also the victim, the ex-victim of a case. So in Spain, as Enrique Galván, the director of Plena Exclusión, mentioned, in Spain we still have a lot to do in things that are linked to the human rights of people with disabilities. And we need much more political will from institutions to be able to join or to be able to guarantee or safeguard the fundamental rights of people with mental disabilities or mental health issues, both in the criminal system and also in prisons. And in the latest report on the National Mechanism to Prevent Torture, and based on the final findings on the report on the report on the rights against culture or other treatment. They called on the Spanish state for a series of practices that don't respect human rights or demanded of the different human rights treaties that Spain has ratified. And some of these concerns are linked to practices as severe, such as the use of mechanical and forced restraints in the penitentiary system, in the criminal system, because we have reports on forced medication to people who suffer from these physical restraint mechanisms, and also the use of these actions to persons with disabilities that have suicidal tendencies. And, well, the comments of this Committee Against Culture made to the Spanish state say that they have to pay attention to the Tokyo rules and the United Nations regulation for the treatment of women prisoner, known as the Bangkok rules. And they have also asked Spain to reinforce the measures, so they keep on making an effort to implement the right measures based on the dynamic security basis in prisons. It has also called on Spain as a member state to review all their actions to try to abolish these forced restraint cases. And as a result, people with mental and psychosocial disabilities that don't get specialized medical treatment either. And what's important about this morning, and what has to do the committees to respect human rights on international level, we want to know, well, the idea today is to get to know firsthand the experience of people who have directly been involved in the criminal justice system, and these people that I am honored to be able to introduce today. These people who are going to be here today are, on the one hand, Eduardo Sárez, expert by experience and a trainer in access to justice, and Tanya Petkova, who is a victim and survivor of institutionalization. And both of them have someone to support them, someone that I'd like to introduce. And in the case of Eduardo, it's Sonia Bermejo. She's here with us. And she's the coordinator of the Prisoner and Access to Justice work team of Plena Inclusión. So for many years, she's been helping people with disabilities in the justice system and in prisons. And she met Eduardo in prison, and both Eduardo and Sonia have been training for. Have been providing training for many years around access to justice, and I would also like to introduce Eduardo himself. Eduardo Suarez Limon, he's 45. He lives in Bonares, in Huelva, and he's a trainer by experience in Plena Inclusión Andalusia, where, amongst other things, he trains other people with intellectual disabilities so they are not subject of abuse. He has collaborated, giving many talks to security forces, also in professional colleges for lawyers and many other professional colleges. And his objective is to raise awareness around the importance to guarantee access to justice for people with disabilities. And next, I'm going to ask him a series of questions so we can all get to know his experience. Eduardo, if I may, let's start with a few questions. And first of all, Eduardo, why are you here today? Today I'm here, so what happened to me does not happen to anybody else ever again, because I had such a bad time that I don't want anybody to go through it. Okay, tell us, which were the events that led you to prison? Well, I had a family business, strawberries and raspberries. We grew strawberries and raspberries. This happened in when I was 27 back then. And so I had a manager. I mean, he did things for me, and I just signed the papers. And at the end, well, some of the papers I was given were not truly legal. And so who came? National police came. They came to the fields where I was working, and they put me in the ground in front of my parents. And well, the worst I've ever gone through. I mean, as if I had killed someone. I did not understand what was happening, and so it was very, very hard. So when you're arrested, you don't know what's happening, right? Or why you're being arrested. No, my parents didn't know either, and they were, surprised and seeing his son being thrown to the ground, and as if he was a criminal, and as if I have done something huge. But I mean, at least talk to me, but don't just throw me, around just like that. And then you were trialed. Tell us about it. How was it? Well, I found a lawyer because I had nothing. I knew nothing about justice, and well, the lawyer told me that it was better to. So there was 6 documents, 6 signatures, and he said that it was better to do it in 6 different trials. But it was much worse for me. I accepted because I was convicted again and again and again, and so I was sentenced to 21 years and 9 months. I had no criminal history or anything else. I had no idea about justice. I trusted the lawyer because I was paying him, and that's what he did to me. And which are the barriers you found? Which one? It has to do with that, right? You did not understand what they did. They did not explain what you were signing. No, nothing at all. And you were not informed about the consequences that this could have for you, right? Yes. And judges, at the end, there was not even a trial. So just stick to 3 years, and because that's better for you, and that's it. And once you were imprisoned, what was your life like in prison? Well, it was very hard. Very weird faces and people with a lot of problems, drugs and true criminals. And really, not something I would recommend to anybody. And once you were in Plena Inclusion's program, what happened? How did it work? Well, thanks to Plena Inclusión, they treated me differently, and my life was much better. But before that, I had to be very careful. They kicked you out of your module, and if you did something, they hit you, and life was very, very hard. So what are you doing now in Plena Inclusión? What are you doing now in Plena Inclusión? Well, what I'm doing now is basically training other people, so what happened to me does not happen to them, so they don't have to go into a justice system without understanding anything. I don't think that's fair. That's right. Would you like to share something else with those who are listening? Yes. I hope nobody else has to go through what I went through. That's it. Given that I had to go through it, I hope nobody else has to go through it again. Thank you very much, Eduardo. Please, huge hand for Eduardo. Thank you. You did great. Thank you. And after hearing Eduardo's experience, it was very, very clear. And well, he transmitted these messages in a very clear and precise way. Well, thank you, Eduardo. Thank you very much. You did great. And I'd like to introduce you to Tania, but I'd like to start talking about also her support person. Tania is going to tell us about her experience, and I will want to talk about Aneta Micheva. She works as a lawyer around human rights and mental health since 1995. She worked for the Helsinki Committee and also in the Mental Health Center till 2013. She's been an independent lawyer since, and she works with the Valeti Foundation. She represented defendants in the cases of Stankovic against Bulgaria, and he's also been involved in monitoring and reviewing institutions all throughout Bulgaria. Aneta is also the founder of the Kera Foundation in Bulgaria, an organization devoted to exploring the loopholes in legislation and their implementation that bring about the violation of human rights of people with disabilities. She's also one of the founders of the Network of Independent Experts and NIE Bulgaria that includes lawyers and other experts in human rights, and they work around mental health and human rights. Aneta and the lawyers in this network, they've been the protagonists of cases to guarantee access to fundamental rights of people with disabilities, including the right that we're most concerned about today, which is the right to have access to justice. She's also a therapist, and she has developed a human rights methodology with art therapy for especially social workers and psychologists. Tania, whenever you want, you can start telling us your experience. Thank you.
My name is Tania. I am 38. I live in Bulgaria, and I am a psychiatric hospital survivor. Thank you very much for your kind invitation and for giving me the privilege to share my personal experience with you. I have been through so much violence that it's going to be very difficult to fit it into 10 minutes. What is worse is that all of the time I didn't even know I was a victim of violence. It's very strange how a child can grow up in an environment in which violence was a norm, and the concept of abuse was unclear because abuse and negligence were a norm as well. It all started when I was 5. My father is a domestic alcoholic, and my mom was subjected to physical violence, and both she and I were victims of emotional violence. This led to violence at high school, where girls from other classes started calling me names and making me give them my allowance. All of this combined resulted in me struggling with bulimia. In my attempts to find a solution, I met online very cruel people who caused me very serious physical and emotional harm by manipulating me to do things that can be classified as torture. Eventually, I ended up in a hospital because one of those cruel people made me cut 96 gashes on my body, which were both deep and long. At the hospital, nobody addressed the violence and talked to me about it. I didn't know it was violence, so I needed someone to explain it to me, to let me know what rights I had, and whom I could turn to for emotional and legal support. What was even worse is when my mom arrived at the hospital and told the staff that I had a mental health diagnosis. I had been taking my meds regularly, so I was not a danger to anyone. The staff told her that if she didn't spend the night with me at the hospital, they would discharge me, even though I had gotten stitched up in just a few hours ago. I'm out of that horrible mess, but many others from all over the world are going through this now while I'm talking to you about it, and they must have trained people and services to reach out to. The things that they are manipulated to do can be lethal, so having the option to have someone to share about this with is a must, and no excuse to not have one is acceptable. In the psychiatric hospitals in Bulgaria, the patient is not a person but an object, and the doctors talk about her in the third person like she's not in the room at all. Sorry, I just lost my alliance. Thank you. Some of them even make jokes or talk with irony. The whole system is a huge mess. Nobody lets patients know what they need and whom to turn to. Everything looks like a dead end, and I'm doing anything I can do to cooperate to improve things. I cannot stress enough how important it is to talk about all these things publicly, because despite the stigma people who have psychosocial difficulties are subjected to, the longer we remain silent and do nothing, the more difficult changing things for the better will become. I know that changing the system is going to be a very long and painful process, but the first step must be done. It must be followed by a second and a third step instead of starting to work on things and then giving up. I am sure I needed someone to reach out to and get access to justice. I don't know any kind of service that helps people who have psychosocial difficulties get access to justice, a fair trial, etc. What I went through is horrid, but what is shocking is that my mind managed to get used to all that abuse and accept it. I think it did that because it was desperate and was determined to survive. The last time I went inpatient was the worst one from one point of view and the best from another. I went inpatient against my own will. I had stopped eating and drinking even water for 4 days, which means I wasn't taking my medications. I wasn't violent, but refused to go to the mental health clinic. Feeling helpless, my mother called the police. There was no mobile service which could help where I lived, so my mom had no other choice but to call the cops. I ignored the policemen for as long as they could, but eventually they managed to put my arms behind my back and put cuffs on my wrists. One of the problems is that I wasn't informed I was being arrested. Another problem is nobody told me what my rights were. As ridiculous as it may sound, I didn't see even that as a form of violence. I believe they were trying to help me and were doing everything for my good. At the psychiatric clinic, I woke up restrained to the bed with an IV in one of my arms. Fortunately, the doctor, who is also a psychotherapist, who saved me from my bulimia, was working there at the hospital, and thank God she took up my treatment again. It's crucial to create a sort of social services which are violence-free. For the girl that I used to be, I want to have several things which are always available. A 24 free hotline that she can call free training and support for the family members to teach them what to do and what not to do in different situations, free training for her, which can teach her to recognize her symptoms and triggers and the different types of violence, social workers and other experts who are very patient, sensitive to violence, and can recognize it, special support for access to justice. I have no idea how this can be done in Bulgaria, but I strongly believe that even if it is difficult, it is also doable. I was blessed enough to meet a very special person who helped me realize what was happening to me, and she did it in the most tender and caring way possible. Thanks to enormous efforts, adequate help, and strong support, I am growing out of all that and have even pressed charges against the psychiatric hospital because they want everyone to have the chance that I had, and they cannot have it at a psychiatric hospital or a small group home. Last year, my father attacked my mom while she was at her home. She and I were living at a place for rent, but she decided to spend the night at her apartment. My drunken father beat her up and almost killed her. She called me in the evening and asked me to let her in the building in which our place for rent was. When we got into our place for rent, I saw that her cheek and neck were bruised. That was the straw that broke the camel's back, and I contacted a friend of mine who is a lawyer immediately. She told us what to do, and finally the police kicked out my father out of my mom's place, and we pressed charges against him. Mom got a restraining order, and in a couple of months they got divorced. So this was the moment in which I saw that getting help was possible. To finish my speech, I would like to say something to everyone, no matter where in the world they are. The fact that there are people who behave in a way that doesn't fit into the norms of the society in which those individuals live does not necessarily mean that they are ill, but they are going through something horrid and extremely painful about which nobody even suspects. Thank you once again for your invitation and for your time and attention. Thank you.
Gracias. Esperemos ahora sí, sí. Queremos, agradecer.
We would like to thank Tania. There's no doubt that her testimony is overwhelming about the pain, the suffering. We would like to thank her for her courage to provide testimony, to be here today overcoming many barriers that sometimes may seem invisible for others, but she has been able to overcome them, and very generously she has shared her testimony with all of us. Thanks, Aneta, also for being with us. And with that, we are going to close this segment about voices in justice, and we are going to turn the floor over to the next presentation about access to justice for people with disabilities, obstacles and promising practices by Wilson Mataria, an expert on the rights of people with disabilities of the International Commission of Jurists. Thanks very much for your attention.
Encantado. Gracias. Sí, tú lo hiciste fenomenal. Entonces todo, vamos, 10. Mejor no serviría, vamos.
Ahora pasaremos a escuchar a
Now we are going to listen to Wilson from the International Commission of Jurists. He is an expert in the rights of people with disability, and he's going to speak about access to justice for people with disabilities.
Sorry, Wilson, we cannot hear you. Can you check, please, if your mic is on? We cannot hear what you're saying. I'm sorry.
I can hear some.
Yeah, I sent. Now I see you are visible, Wilson,
Bueno,
on
te veo
the
ahora.
screen.
Okay, that's hearing.
They
So
can
now we
hear
are
us.
on audio. So we are waiting for the audio now.
Bueno, no sé si funciona.
Everyone in the room, can you hear me now?
¿Va?
Can you hear me in the room?
I guess they still cannot hear.
To go first, because you can go first. I'll just have
If you would like, yeah.
No, that's okay, because you can go first.
Yeah, I can go.
Okay. Would you like to sit here then, so that I take the other seat?
Yeah, you can.
Because, it will be easier. Okay. Okay, cool. That's okay. Good.
Ahora vamos a escuchar a la siguiente mesa.
Now we are going to listen to the next round table. They are going to speak about how we can make adjustments so that justice is more accessible for people with disabilities.
Okay, welcome everyone. I can hear that you can hear me, so that's perfect.
So today we have a panel on identification and provision of accommodation needs in criminal proceedings. My name is Gabrielle. I'm from Mental Health Perspectives, one of the Enable project partners in Lithuania. And here with me, you can see Professor Gautam Gulati, who's a consultant forensic psychiatrist in Ireland. And he holds research doctorates in forensic psychiatry and law, which is very impressive. And he's also an author of textbooks, over 100 papers and abstracts, who has contributed to human rights initiatives in Ireland and a number of EU member states and the US. So a lot of useful experience we can hopefully touch on today. We then have Sonia Bermejo Valverde, expert in the field of disability and specialist in psychopathology and health. And with extensive experience in intellectual disabilities, Sonia has been coordinating for years the program of care for people with intellectual and development disabilities in prison, ex-prisoners, and those serving alternative measures. So again, thank you for bringing your expertise into this panel. And then we have Anna Arganashvili, who's a litigation officer at the Validity Foundation with an academic background and professional practice in occupational therapy and psychology. And as I understand, before joining Validity, Anna has litigated cases involving human rights violations, affecting persons with disabilities, children, women, both in domestic courts and in international forums. So again, a lot of useful experience. Thank you for being here. So yeah, today in this panel we'll cover some of the findings from our project national briefing papers on procedural accommodation needs assessments, and then also discuss how and when legal procedural accommodation needs assessments come into play. When do they start? What are the promising practices on the inclusive needs, and how can they be replicated across different countries? So maybe just to start, for example, I'll give you an example from Lithuania. What we found during a research stage was that the project is that identification of the needs is not a straightforward process, and it differs quite greatly across different countries. So it's great that we have speakers from different countries. For example, in Lithuania, we have no formal requirement for the identification. Sometimes the needs are only assessed once the defendant enters the prison system, which of course isn't ideal. And even though there are justice professionals willing to help, who recognize the need and the importance of accommodation, when there's no legal let's say, certainty or regulations, this imposes significant challenges in providing the measures for the defendants. So, yeah. Now, to build on that, maybe let's start with Anna. At what point would you say in criminal proceedings are state representatives required to identify the needs and to provide procedural accommodation according to human rights principles?
Thank you so much. And before I start my presentation to answer your question, I really want to thank you to Eduardo and Tanya. This was the biggest lesson I learned, and thank you for your courage and for your sharing. So, in response to your question, yes, we all know that the right to procedural accommodation applies from the very first contact with law enforcement and justice system, but it's easier than done. And Validity works in many countries. And some of the countries are not that advanced as we see partners in this conference hall and those who participated in the publication. So I will focus on three major challenges that we see in international and domestic litigation in terms of applying procedural accommodations. The first big challenge is that, of course, it's a person with disability who should request the procedural accommodation. But at the same time, we see when there is an absence of procedural accommodation, courts often say that it was the burden of this person to be insisting on procedural accommodation, while they might not have information, they might not have been provided with the options. So we see that in these cases, simply it's not provided. Another very important challenge, and Eduardo mentioned today, is the power of lawyers and legal counsels. We observe that international courts often say that vulnerability is compensated by a lawyer, and that lawyer is expected to raise the issue and to advocate. But what happens if the lawyer is not aware, doesn't have this information or education, or simply doesn't care? And we, the lawyers, have a lot of power. And I think that I should also bring the latest judgment from the European Court of Human Rights, and I'm very proud because Validity has contributed as a third-party intervener in this judgment, and it was delivered on June 6, 2024. And the case referred to a woman with psychosocial disabilities who was charged with some criminal liability, and forensic expert concluded that she could not participate in the hearing, and she warranted her to be placed in the psychiatric hospital. She was assigned a lawyer, actually 2 of them, and they unfortunately represented her manifestly passive and contrary to her interests, and openly supported prosecutors' position. Moreover, the counselor did not appeal the judgment, and she herself didn't have a chance to appeal. Validity's position was that persons with psychosocial disabilities are active agents, and whether directing the legal counsels or making their applications. So it's discriminatory to presume that a person cannot participate in such proceedings. And European Court ruled that the legal assistance provided to the applicant was seriously and manifestly deficient, both on substantive and procedural issues, and the court found that the quality of the legal aid to the applicant could not meet the requirements of the Article 6. So this should be a wake-up call for lawyers who often have a position that legal profession is independent, and sometimes we have too much power. Another challenge is the identification of needs, as you mentioned. So it's often related to the assessments, and assessments doesn't have a good reputation based on the medical trend. So the pattern we see in litigation is that prosecutorial and judicial authorities are eager to assess fitness to send trial, but that assessment doesn't have anything to do with the procedural accommodations, and we really face the challenge to not categorize a person, to not put in the box. And here I would like to refer to Catalina De Vandes, ex-UN Special Reporter for the Rights of a Person with Disabilities, and she indicating that making any assessment CRPD compliant means considering the impact of environmental and contextual factors, not making assumptions based on the disability and impairment, and that CRPD compliant disability assessment should abide with the purpose, principles, and the rights of the person. So this assessment cannot restrict the rights. So disability assessment should be respectful of the dignity, of the privacy, of the choice not to be assessed. And I think the question also referred to a general observation, what we observe in the international litigation practices. And I want to give you a small example. Imagine that I'm unable to ride a bicycle, and then one day happens some kind of natural disaster, and the only way to save my life is through riding a bicycle. But this is the first day for me to riding a bicycle. And can we imagine that I can succeed? It's less likely. And this is an analogy for me of the court hearing. Because if a person has never requested and being provided before procedural accommodations, then to expect him or her to be actively advocating for the procedural accommodation in the court hearing is, well, less likely. Currently, both domestic and international courts expect persons with disabilities to fight for procedural accommodation during the proceedings, control the quality of legal aid, manage potential conflicts of interest with different parties, and sometimes challenge the only source of assistance they have. And I'd like to bring a quote from one of the judgments. So we see, apart from the court hearing where steps were taken enabling her to understand the questions asked, the applicant didn't point to any indication in the records that she had difficulty understanding of expressing herself, nor did the court, having interviewed the applicant during the investigation, notice anything particular. Had the applicant considered herself unprepared for the interviews or needed any further explanation or assistance, it was incumbent on her and her lawyer to bring such concerns to the attention of the authorities. So why couldn't she raise this issue? Because she simply didn't have this experience of requesting accommodations beforehand. And this is the approach that we should see the courtroom and the justice system as a part of a bigger picture, where the education, employment, social welfare, health, and justice is all interconnected. And last but not least, as you are probably all aware, last week there was 17th session of the Conference of State Parties on the Convention of the Persons with Disabilities. And during the very last side event, it was hybrid. I had a chance to ask to one of the UN committee members whether UNCRPD proceedings involved any kind of procedural accommodations. And the answer was no. And that's why currently the rules of procedures are being revised. So there is still
And it could lead to an exclusion from participation, which none of us want. So these are the three ways the world is doing it. I think we need to move towards a more universal way of looking at this. Firstly, 3 points. Firstly, a person themselves must be able to self-report a disability or a need for procedural accommodations at any point of their pathway, and should be empowered with an advocate to do that, and shouldn't just be at initial screening. The second is every member of the justice system, whether it's court clerks, judiciary, lawyers, doctors, they should be fully trained in disability awareness, but also the importance of procedural accommodations. And thirdly, and finally, again, this is a universal thing. It doesn't depend on jurisdiction. Everybody must get these 3 safeguards. One, if someone's deprived their liberty, one, for them to make a call, to have a third person notified, usually a family member. Second, to have a lawyer, and third, to have a doctor available to them. Why is this important? It's because that family member can tell the justice system or attend in person, be the support person, say, hang on, my son, my daughter, my husband, my wife, they need a hearing aid, they might need a support person, they might have a sensory issue. So they have a wonderful source of support and information, this third party. The second is the lawyer, and Anna, you quite rightly mentioned the important role of lawyers. A good trained lawyer will be able to say, hang on, we're going to stop this process, we're going to pause this process. My client here needs an intermediary. I'm clearly finding there's a need for communication support. Can we get someone who's a trained intermediary, might have speech and language training? And the third is the presence of a doctor. And the doctor's involvement must only be with the consent of the individual involved. But a doctor, with the person's consent, might be in a position to advocate, say, this, the person here through the justice system needs corrective lenses, they might need hearing aids, they might need sign language, they might need sensory accommodations. Something as simple as the fluorescent lights in police stations, they can be quite distressing for people with autism spectrum disorder, for example. So a doctor, with the consent of the person, might be in a good position. So that's quite a long answer, but they're the universal ways of providing the safeguards.
It's very well structured, so thank you for covering now. How do procedural accommodations foster the equal participation of people with intellectual and psychosocial disabilities, again, speaking about the judicial proceedings?
Okay. I think that the key word in there is the equal participation. What must never happen is that a disability is recognized and then it's used as a basis to exclude someone from their participation. It is the enabling. I think that needs a change in societal attitudes, it needs a change in law.
Okay, so there's a few elements to that. Thank you for answering. Now maybe Sonia, from the research carried out within the Enable project, we've learned that Spain is quite ahead of other European countries when it comes to identification of participation barriers and the accommodation measures. So could you tell us about the mechanisms available in Spain for recognizing these barriers?
Buenos días.
Good morning everybody. First of all, I'd like to thank you all for being here. I'd like to take the opportunity to thank you for the work you're doing from Enable. And here we are able to share viewpoints from different countries. And we can probably set a solid basis so the process to access justice, this process are more consolidated. So answering your question, and on barriers, the commitment to eliminate barriers and to provide accommodations. In Spain, this is more consolidated given that we already have legislation about it. Slowly, the Spanish legal framework is becoming more favorable, consolidating the recognition of the needed, these needed accommodations. As we know, the convention that was it's applicable in Spain since 2008 set solid basis because it guarantees equal access to justice. through the use of specific accommodations, this international commitment has been has also Law 8/2021 here in Spain, so a specific Spanish legislation that changes procedural law and includes this crucial Article 7 in the voluntary jurisdiction laws. And this piece of legislation not only include accommodation in all the procedural phases, but they also guarantee the facilitator, which is essential to make sure that people with disabilities can have full access to the legal system. We also have Royal Decree 7/2023 that changes criminal law to include the role of the facilitator as well. Also, Law 4/15 of the victim status that opens offices so victims can get the support they need. Having said that, these regulations reflect a legal framework that's more inclusive and that's more committed to justice, so it's accessible to all. And on the other hand, and we should say this as well, the role of the third sector institutions is capital. Institutions like CERMI or Plena Inclusión, because although regulations gave us legal grounds, the effective practice of these mechanisms have been pushed by organizations such as Plena Inclusión, organizations from the sex sector, who have a long track record in the world of disability. Plena Inclusión has led the practical implementation of these accommodations. It has had an essential role in the development of specific programs that tackle these communication and contextual barriers that people with disabilities are facing through the program with prisoners, and Enrique mentioned for over 30 years. Many of our colleagues who are here today and myself, we have made this discovery because we have suffered it. We have suffered these barriers as well. Professionals are suffering these barriers as well, so we know very well what these barriers are. So we have been able to configure this role of a facilitator through work groups and research groups and the daily work of these professionals that have accompanied people with disabilities in these processes, and they have identified and eliminated these barriers slowly. Making proposals when we had no regulations, when we were not even talking about the accommodations. So imagine when a subject in a process, whatever it may be, can be civil, criminal, administrative, any kind of process, when that person has any sort of disability, may it be physical, sensory, mental, they have to be treated as a person that is especially sensitive. And topics that might look easy for us, like technical language, for example, or how strict they are in the hearings, or well, they position people with disabilities in a very weak situation. That's right. So, another mechanism that's essential to recognize these barriers has been ongoing training for legal operators, and thanks to that, legal workers are more aware and they are better trained to identify these disabilities, and so to be able to identify the barriers that these persons might encounter participating in this forum with experts like Eduardo, because Eduardo is already an expert, or the participation of Tania. They are it's very important testimony of people who have suffered it, and they are examples on how to raise awareness amongst legal workers, put these real experiences on the table. The experience of those people who are facing these barriers is essential to be able to understand more deeply these challenges, these testimonies. They are able to get rid of these barriers. Another way to tackle these barriers is that we have bet on quality training for professionals who are going to be facilitators. They are actually the expert that's going to carry out these necessary adjustments to get rid of those barriers. One, that they go through this training. Facilitators are going to add to the process knowledge on the rights of people with disabilities, knowledge and experience in treating people with disabilities, and also knowledge around everything. So they are able to identify the barriers. And how are they going to do it? They do it through a study or assessment of these persons. And they have to explain in a report in which they will explain the implementation of those adjustments and accommodations. They have to make sure that everything is explained in a language that's easy to understand. Well, so the facilitator is able to develop their tasks. It is essential for them to get the right training. That's why we have established a collaboration with Spanish universities to develop a university experts. And these programs are designed to make sure facilitators have a quality knowledge, and they make sure that they are accredited, so to make sure they are properly trained. And as a summary, to answer your question, although there's still a very long path to walk, the mechanisms that are available right now in Spain to be able to recognize the barriers and implement the needed support. Well, the thing is, we have laws that help us, the work of organizations like Plena Inclusión, the constant awareness work we carry out with legal operators, the training in the universities so facilitators can do a good job, and also having people like Tania and Eduardo advocating for the things that they have gone through.
All right, so what would you say are the tools used to identify the needs and barriers of specific groups requiring additional support of judicial proceedings? So women, elderly, migrants, persons in institutions.
Okay, vale.
All right, well, there are no tools or protocols designed for groups that are more or less vulnerable, like women, the elderly, or migrants. Of course, there are some people who will require more support than others, but the key to be able to reduce those barriers is to customize. So, see each person as someone unique. So we talk about, we are talking about these recommendations because there are no rules that are applicable to everybody. So we have to analyze each case individually because each person has its own difficulties that require specific assessment. So we should try to avoid generalization and using stereotypes for everybody. And the disability social model explains that barriers are not in the limitation of the person, but also in the environment as well. So although it is clearly essential to be able to clearly identify the areas in which this person needs support, like possible sensory or cognitive intellectual limitations that are linked to their own disability. These barriers, both limitation in communication and understanding and in their relationship with other people, this has to be implemented in a context, and we need to carry out a specific assessment on how to help that person. So there's no formula for vulnerable populations beyond customizing them. And this is known as the customized profile for reasonable accommodations. So the person with a disability should have to be listened to. Also, gather information in the right way will avoid having the rights of these persons breached. So it's important to highlight the very important role of the facilitator throughout the whole process, because with their knowledge they can carry out accommodations directly, or else indicate how those accommodations should be carried out, even if they won't always be able to execute them. If, for example, if we require information, easy reading information, the facilitator will determine that need, but this has to be adopted by someone with the right training. Same thing, this person's using a hearing aid or corrective lenses. The facilitator can request having someone who's familiarized with the system and understanding the contextual barriers. I'm proposing customized accommodations will reduce the limitations caused by this disability. It doesn't really matter if this person requires more or less accommodation. So adapting the context as well. It will be useless if someone with a disability knows they have the right to sue or report something to the police, and where they can do it if the format is not accessible. And last, I'm thinking about the impact of these procedural adjustments. These accommodations have the potential to transform lives. We've seen it here with Eduardo and Tania. They allow a better participation in these cases.
From audience, yeah. Would anyone like to ask a question? Here.
Yeah, just 2 questions, please, and then until then we can eventually try to pull on the screen Wilson, please. Thank you.
Okay.
Okay, en español supongo.
In Spanish? Yes, hello. If possible, it would be great if you can tell us how you were able to get to the role of the facilitator, how you were able to change the framework, because this is a cultural transformation, a very relevant cultural transformation. I guess that in Latin America we're quite far from it. So I'd like to know what the story behind achieving something like that. Well, we had previous experience, and with the prisoner program for over 30 years, we have accompanied people with disabilities in police processes and legal process. So for professionals who have been doing this for a long time, well, we suffered it. We have suffered these barriers. We have gone there with our reports. We've gone to one call, another call in the police. We thought nobody paying attention to it, so we have suffered those barriers as well. So we were able to identify them properly, and besides identifying them, we have always fought to try to solve them. So I believe the facilitator has been built slowly, as we've been able to solve one barrier and the next one. And now with this law, the truth is that we got this extra motivation for it. It's already in our law, and so it's easier for us. We have that law, and so we don't have to knock on doors where nobody paid any attention to you. So you've got the laws, you've got your experience. You have this constant training we are providing to make sure that courts and judges and attorneys and everybody else, all legal operators are more aware. So this is not something that was done in a day. It's been 30 years in which we've been planting seeds and more seeds. And I think that we're still a lot to do, but I think we're getting there. In fact, we have many positive cases in which judges talk to a person with disability in a language that's easy to understand, and how judges are collaborating with the facilitator so they can be understood, and how the attorney caters for our requests, our lawyer are more aware. So I think that it came through our daily job, the daily job we've carried out. We have also worked in different work groups and expert groups to be able to configure this role, the facilitator role. We change it every day because we've always found that there were things to improve. We carried out pilots for forensic psychologists, also for the facilitator, and it's been fruitful. And this year we're starting the expert program. So constant work with groups of experts and people who work on it every day. So we are slowly seeing it come to fruition.
If there are other questions, preferably please mention who you are directing the question to. Thank you.
Thank you very much. Very interesting to learn about all of your experiences. One of my experiences is that a lot of justice professionals remain unwilling to make procedural accommodations. Sometimes they believe that, for example, bringing an intermediary will damage the evidence that is given in a trial. Or sometimes they believe having a support person in the courtroom will undermine the fact-finding role of the court. What's your response to that? Because these are some of the very traditional perspectives we often hear from judges, particularly in criminal law. Thank you.
Everyone, one sentence? Yeah.
I can start. I think first, maybe we should challenge if the facts are actually as they believe, that evidence is lost, or maybe vice versa. And then if the facts are not supporting their assumptions, then we can question what is wrong with us, legal professionals. Maybe it's about power.
Well, we should clarify that the role of the facilitator is neutral, and that's they are impartial and neutral. That's another topic that's why we train forensic psychologists, and we help them understand why we were there. We have also worked on the role of everyone involved. That's why we've reinforced the idea that the facilitator can collaborate with forensic psychologists in the hearing, so the person with disability is able to understand the questions. So the work we have done in terms of training and awareness to all the professionals involved, especially legal operator, has been devoted to try to address the role of the facilitator and try to show that it's a neutral, someone that's neutral, and they don't have to be involved in the process, but rather in the communication and making sure that communication is effective.
I think something can be said about the importance of training judiciary and the people in court. If you look at, and we did this, if you look at every country that's ratified the UN CRPD, and they submit periodic reports and interim reports, and these are all held in the UN treaty bodies database. So what I did was I went back and looked at each one of those reports, 123 of them, for 123 countries, and checked how many of these countries actually report training the judiciary. So about 30% train the judiciary, about 25% train police officers, about 10% train their solicitors, and even lesser train their prosecutors. So there's something to be said about a lot more awareness raising and training.
Thank you everyone. A lot of useful observations. And now we're going to the, yeah.
Thank you, Gabriele. Thank you, dear panel speakers. I think this panel definitely deserves a huge round of applause. Thank you, everyone. I think we will try to get Wilson on screen once more. Thank you. We will postpone the break maybe with 10 minutes tops. So, yeah, hope you are still energetic for our key speaker notes. So, okay. Thank you so much.
Thank you.
Working on it. Mm-hmm.
Yeah. Can you hear me? Can you hear me, Ion? Can you hear me, Ion? Okay. Thank you very much. I am now told that you can hear me. Um, I'll just have to perhaps start with apologies. I'm getting some feedback. Can you still hear me now? Okay, great. Thank you very much to everyone, and thank you for your patience as we were sorting out the technical issues. My name is Wilson Masharia, and I am happy to be joining this conference, albeit online. I work with the International Commission of Jurists, but I'm currently based in Nairobi, Kenya. I serve as a legal advisor where I implement projects on disability rights globally and within the region in Africa. Perhaps it's also important for me to mention that I am a person with disability myself. I'm visually impaired, in other terms, blind. And I have also interacted with the justice system in various capacities, um, as a petitioner or litigator before a case, but also as a lawyer representing other people, specifically in the justice system. I'll start with a brief introduction of the International Commission of Jurists, which is a global organization, international non-governmental organization, with the headquarters in Geneva, but have offices and staff in different regions around the world. Our work revolves around safeguarding the rule of law, advocating for the full human rights of all people, including the right to access to justice, and defending the independence of judges and lawyers around the world. We do this through research, through capacity building of various stakeholders, and through interventions, at times through litigation. Our work on disability has, has had some impact globally, but what we focus on is providing technical and other support to organizations of persons with disabilities and persons with disabilities themselves in undertaking advocacy on disability rights. Some of the activities that we have done so far include leading or hosting, in collaboration with other partners, regional engagements or consultations specifically on access to justice for persons with disabilities. We had a regional convening in September 2023 in Latin America, hosted in Colombia, where we collaborated with Documenta and other organizations to bring together persons with disabilities, justice actors, including prosecutors and judges, speak on how to ensure the full participation of persons with disabilities at an equal basis with others in the justice system. We also recently, about 3 weeks ago, held a regional convening in Asia, specifically in Nepal, and we would be hosting a regional convening on the same conversation in Africa, perhaps in the beginning of May or mid of next year. The reason why we are having regional convenings is because we acknowledge and understand that the context for persons with disabilities in different regions and also specifically in different states is different. And therefore, it is important for persons with disabilities to propose or suggest ways in which access to justice can be enhanced for them, their individual selves. Some of the work or the outcomes that we have seen through our involvement is we participated in the adoption of the special rapporteurs, principles, and guidelines on access to justice for persons with disabilities, which have been spoken on, and also advocating for the ratification, but also implementation of a regional instrument, African regional instrument, which is referred to as the Africa Disability Protocol. It provides for same rights, just as the CRPD, contextualizes it in Africa, and I'm glad to inform us that this instrument recently came into force, which we are celebrating as persons with disabilities within the region. We have also worked with organizations of persons with disabilities in specific national context. For instance, in 2022, we provided support to the Lesotho National Federation of Disabled Persons Organizations to advocate for the development and adoption of judicial rules on providing procedural, reasonable, and other supports and accommodations to persons with disabilities who interact with the justice system. These rules were recently adopted by the Chief Justice of Lesotho and are currently in force. Coming back to the conversation which brings us together today, it is all important to first identify the barriers that impede access to justice for persons with disabilities around the world. And I will not dwell on this so much because previous speakers have already alluded to them. And some of the barriers that have come up in the previous conversations have been on attitudinal barriers, where attitudes and negative perceptions by the society, and in this case, the justice actors, impede full and effective access to justice for persons with disabilities at an equal basis with others. There are also environmental barriers, the infrastructure where the courts are located, but also generally the infrastructure that we have within our countries, towns, and cities that make it difficult for persons with disabilities to access justice infrastructure. There are institutional barriers, but perhaps even more importantly, in this case, legal barriers, laws that have been created or were created traditionally and have not been amended or repealed, and they continue to make it or to cause barriers for persons with disabilities when interacting with the justice system. And this is more so in the criminal justice system as it is in the civil justice system, but allow me to focus on the criminal justice system. In our advocacy around the world as the International Commission of Jurists, but also in my capacity as a person with disability, we have come to realize that the barriers that persons with disabilities face are more similar than different. That the differences or the laws that different jurisdictions and courts use to deny access to justice are very similar in nature. For instance, in most countries, including the ones we are from, and I will also speak on the context of my country, which is Kenya, we have mental status assessments, which are often undertaken before persons with disabilities participate in the hearing. And unfortunately, this leads to denial of access to justice for persons with disabilities, and especially persons with intellectual and psychosocial disabilities. And following that, persons with disabilities are also subjected to substituted decision making, where after these mental status assessments are undertaken, the justice system often relies on other people to make decisions on behalf of and not in support of persons with disabilities. And where does that lead us? It leads us to a violation of also other rights which persons with disabilities ideally should enjoy on an equal basis with others. This includes the right to equality and non-discrimination, the right to access to justice, the right to life, the right to liberty, freedom from torture, but also the right to live equally in the community and being included in the community. These violations are often faced by categories or groups of persons with disabilities, which are often underrepresented in the justice system. And especially in this case, persons with intellectual and psychosocial disabilities. How is that the case? The procedures that are used by courts around the world in the criminal justice system do not recognize or do not have a system of identifying the procedural accommodations or supports that persons with disabilities require to access the justice system fully and effectively. Instead, they have procedures that place persons with disabilities in institutions when they are found to not have capacity to identify the proceedings. And unfortunately, these procedures are undertaken without consulting or the involvement of the individual persons with disabilities. For example, we recently, me as Wilson Masharia, but also with other justice sector actors, including judges, magistrates, and prosecutors, undertook a visit of a mental health institution, which is referred to as Mathare here in Kenya. And what I realized, of course, I wasn't surprised, but persons who work in the justice system, the judges, the magistrates, and prosecutors who accompanied us were also surprised by the situation in which persons with disabilities are placed in those institutions. But perhaps what surprised them the most is that those people who are in institutions were able to recall how exactly they were put into the mental health institution, how long they have been in that institution, and what efforts they have tried in order to go back to their communities, to their families, and to their societies. Before that, the judges used to look at these individuals as files, court files before them. But after that visit, which I hope should take place more often, the judges and other justice actors started viewing these individuals as people capable of holding rights, knowing their rights, and exercising their rights. In Kenya, we've also had several attempts to litigate or to challenge the procedures that lead to the institutionalization of persons with psychosocial disabilities based upon mental status assessments. We have had some wins, but also have some losses. But what hurts me the most is that we have had not one, not two, but several decisions, court decisions in which some of these laws have been found to be unconstitutional, but the practices still continue. We have also had some judges try to apply the CRPD and the principles of equality and non-discrimination, including the recognition of legal capacity, but apply them differently in what is now termed as jurisprudential chaos. The reason for that is because beyond the capacity building that has been taking place, we do not have standards, we do not have regulations, we do not have existing laws or judicial procedure laws that actually recognize these procedural accommodations. And that is why I will conclude with a call for action, which has already begun with the interaction that we are having today. We need to join hands to speed up efforts to fight or to push for the review, the repealing, the amendment, and adoption of laws that recognize the legal capacity of persons with disabilities and their right to access fair trial and access to justice at an equal basis with others. We also need to advocate for the abolishment of procedures and practices that lead to denial of access to justice and legal capacity. And this should be done as we continue to build the capacity, even involve them in our advocacy efforts, the capacity of justice actors. But perhaps most importantly, as we undertake all these advocacy efforts, we should make sure that persons with disabilities, and especially the underrepresented, persons with intellectual and psychosocial disabilities, are part of these processes. We have a good guidance tool under the Convention of the Rights of Persons with Disabilities and other standards that have been adopted by the committee. And these procedures, laws, and this instrument was adapted or developed by persons with disabilities themselves. And it then follows that as persons with disabilities, we ought to be involved in efforts to implement these laws. We are the ones who fought for them, who participated in developing them, and should equally participate in implementing the laws. Thank you, and that is all from my part.
Yeah, I was hoping to have maybe one or two questions to Wilson, but yeah, I think we'll just grab a coffee, and eventually, if he will be around, we can ask for a question later. But until then, please welcome to have a coffee break, and if we can kindly ask you to come back at 12:20 in 15 minutes. Thank you so much. Jordan, I'm sorry, my mistake. We have a few words from Jordan, then the coffee break. Thank you.
It was very interesting to listen to Wilson. With what we have heard today and what we've been told, I think that we can have food for thought and some instruments to try to make justice more accessible. Now with this message, I think that we can take a small break and grab a coffee. Thank you.
1, 2, 3, 4, 5, 6, 7.
Thank you.
Hello, hello. Hello, hello. Yeah? Super. I need Natalia. Natalia is not here. Hi, everyone. Can we please ask you to come back to the meeting room? Natalia, sorry, can we move to the... Anna, can you please help everyone to come to the...
Y luego con el juzgado también mal, porque a la...
Well, I don't need the mic. No. Thank you, Pablo.
Phew. Yeah, it's gonna be good.
Ajá. Ah, vale. Ok. Y luego ya empieza ya John. Vale, nos preguntaba que si iba intercalando las preguntas, una a Nico, otra a mí, y hemos dicho que mejor primero todas las de Nico, para que él prefiere acabar lo antes posible, y luego ya cuando finalice con él, pues ya que me hace las preguntas mías.
Vale, gracias.
Sí, hombre. Que sí, hombre, ya verás cómo lo vas a hacer súper bien. Es ponte cómodo.
Sí,
que
no,
no
sí,
esté...
cómodo estoy, Sara, porque estoy muy nervioso.
Ven, que yo me acerco aquí contigo. Ya verás, y además como estamos aquí, tú me las puedes explicar diciéndome a mí, ¿sabes?
Yes, yeah.
¿Y Alba cómo está? ¿Y el Luca?
Es que ya se escucha.
Ah, se escucha.
Axel? Axel? Please take the mic, invite everyone in. Or, yeah, okay.
Esperamos que el café haya servido para despertar.
We hope that coffee was good to wake you up again. And now we go to the next roundtable where we are going to hear how you can have good experiences when you count on the right support.
Hello, everyone. Welcome to the next panel that we're having today. Just a technical question to make sure that our other two speakers are already connected. If I can have like a confirmation about that at some point. Yeah? Okay, superb. As Jorda was mentioning, we hope that everyone is energized for another 2 sessions. They're going to be exciting, not less exciting than the previous ones. So I hope you are looking forward to them exactly as we do. So just 2 words about myself to introduce myself. My name is Ioan Schidu. I am the Enable project manager. Before coming to the Validity Foundation, I was a human rights litigator in Moldova. I've litigated cases of discrimination and human rights abuse against persons with intellectual and psychosocial disabilities, different type of cases, in criminal proceedings, labor proceedings, civil proceedings, mostly related to ill treatment and discrimination. We have an extraordinary panel here once more, as in all the other ones. We have Nicolas Garcia. He's a person with intellectual and psychosocial disability. Nicolas is currently serving a sentence in the Madrid 7 Penitentiary Center in the specific module for people with intellectual and psychosocial disabilities. Nicolas was detected with having a psychosocial and intellectual disability when he was 32, when he was then going through judicial procedures without the implementation of procedural adjustment at that point. Then he met colleagues from Plena Inclusion who provided him the necessary support to once more go through those procedures, already having the necessary accommodations. Then we as well, we are happy to salute Sara Lendines to this panel. Sara is the coordinator of the program on access to justice and detention in Plena Inclusion Madrid. Sara is herself a procedural facilitator and has facilitated procedural adjustments required by people with intellectual and psychosocial disabilities, especially in the criminal field. Then we have another 2 participants joining us online. This is Roxana Komsa. She's a judicial and rule of law expert with over 20 years of experience. Roxana formerly worked as a national judge in her native Romania. Later, she worked as an international judge in Kosovo. There, she adjudicated cases of trafficking of human beings, corruption, and war crimes. She's an expert for the Council of Europe, specialized in international criminal justice, transnational crimes, juvenile justice, access to justice, and justice reforms. Last but not least, we have Karolina Babička. Karolina is a senior legal advisor in the Europe and Central Asia program of the International Commission of Jurists. She holds a PhD in international law. She's an international human rights lawyer, and her work is focused mainly on issues related to access to justice for the most vulnerable through strategic litigation, research, and advocacy. So before giving the floor to our honorable panelists, I think it would be important to say a few words about the findings that we had within the Enable project. So we researched the situation regarding the access to justice for defendants with intellectual and psychosocial disabilities in 8 EU countries. This is Romania, Bulgaria, Czechia, Slovenia, Slovakia, Lithuania, Spain, and Portugal. So we looked through their legislation. We looked how are those legal barriers embedded in the national legislation. Then we as well carried out interviews with practitioners, judges, lawyers, prosecutors, but we as well spoke with defendants with intellectual and psychosocial disabilities regarding their experiences participating in criminal proceedings. All in all, I think we will not say the research just confirmed once more what you already heard in this event for a few times. So when it comes to legal barriers, or maybe I first will say a very important assessment or finding is that all of those participating countries are a party, as you assume, to the CRPD. They all ratified the convention without any reservation or objections, referring to Article 12 and 13 of the CRPD. But then at the same time, the UN CRPD committee has made several notifications to all of those states regarding the work that the national government has to carry out at the national level in order to ensure that persons with intellectual and psychosocial disabilities are not discriminated within the justice process. the findings. So again, as we spoke, the National Legal Framework on Access to Justice, this is another line. So laws in most countries allow still deprivation of legal capacity. So this is, again, the circumstances when persons, after their legal capacity being taken from them, they cannot participate equally in criminal proceedings. They are declared as incapable to stand trial, but then on the other hand, they often after that are placed in forensic detention. The criminal procedural codes of those countries do not provide any form of procedural accommodation specifically for defendants with intellectual and psychosocial disabilities. Besides the legal barriers, we of course looked into what is the de facto situation. So, as again was spoken a few times during this event, often the disability of a person is identified already when the person is serving their sentence in detention. So basically, most of them can go through whole criminal proceedings in all three instances very often without any type of procedural accommodation, which is a huge problem. As well from the concerns of procedural rights, but on the other hand of fair outcomes of those criminal proceedings. What we've noticed as well is that the forensic examination or the examination of persons, defendants participating in proceedings is mostly done from a forensic perspective. So basically, again, the assessment is made in order to disqualify the person to participate in proceedings rather than to support them and provide them with necessarily adjustments. There are as well a few promising things that we need to mention. So still, a legislation of some countries provide accommodations in civil proceedings, which can be then transposed to criminal proceedings and for defendants. Then we've noticed that criminal justice professionals, usually without due legislation in place, still are perceiving the barriers of person participating in processes, and they allow for accommodations. For example, they speak slower, they accommodate their language, they offer often access to their relatives to be their support persons without actually being a legislation in place. So it's a mix of things that we found. We found that there are regretfully many things that are not that good. From the legal barriers and then de facto barriers, but on the other hand, there are a few good things that were discussed today that can be already replicated in other countries. So, as I already spoke 1.5 minutes beyond my time, I would like to warmly once again welcome Nicolas to the panel and ask him how was the experience for him to participate in a criminal justice in a process.
Bueno, buenos días a todos y a todas. Nicolás, te da la bienvenida.
Good morning, everyone. Nicolas is welcoming you, and he wants to ask you what was your experience like with the criminal justice system. Well, I was arrested by the police. I was ill-treated. I was not informed. I didn't know what they were doing. They were asking me weird questions, both prosecutors and judges, and I just was unable to find out what was happening. Yeah, so that's to start with. Those were your first experiences. And then, when do they detect your disability? That was in 2013. And after 2013, have you had any court trials? Yes. And what was your experience like then? Well, more or less the same. Police explained things to me that I didn't understand. Then judges and prosecutors, I was not able to understand them. And they were asking questions, weird questions, very fast. And I was not able to really understand. Were you telling the lawyers or the police that you had a disability? No, I didn't. Why? Because I was so nervous that I just couldn't remember to tell them. Okay. And then you got to plena inclusión. When was that? In 2021. And after 2021, have you had any other proceeding? Yes. And what were they like? Well, that was much better, much better. Why? What were the differences? Because there was the facilitator, and she explained things to me clearly, and also the lawyer was explaining it much clearer to me, and it was very different from when I didn't have that role of the facilitator, and I was able to find out more what was happening at every point. So thanks to you.
Nicolas, and thank you so much, Sarah, for facilitating this. In your accommodations, what worked well for you, Nicolas, and what worked less great? What is your experience with better practice of providing accommodations, and what was not really suited to your situation? I think more to Nicolas.
Vale, ¿cuál ha sido la...
So, your best experience when you did not have a facilitator, which were the things that were not working? So when you did not have a facilitator, why was it hard for you to understand what was happening? Probably due to my disability and because everything was being explained very fast. Okay, what was the difference in the speed when you had a facilitator? Sorry, what was that again? What was the difference when you had a facilitator in trial? What was the difference you felt? Everything was explained properly with words that I was able to understand. It was easier. Okay.
Thank you, Nicolas. Was the communication facilitated in regards to every criminal justice actor, for example, in communication with law enforcement bodies as police, prosecution, and judges? So was it facilitated within all these sectors from the system? And yeah, what do you think what groups were easier to interact with, and what groups were more complicated from those lawyers, judges, prosecutors, whom were more cooperatives, maybe?
So throughout, in all the process, judges, prosecutors, lawyers, and with all these people you had to talk, who did you find it harder to talk to? The judges. The judges, okay. And the easiest one? With the police.
Very interesting development. We would usually say, I think, that the lawyers are the ones who you would be easier to speak. Why did he felt that maybe the lawyers were excluded from this maybe good experience? And why judges were more complicated? Obviously, we're going off the script now, because this is like super interesting.
Dice que es muy interesante.
He's saying that's very interesting because it's normally the lawyers, the people they find it harder to talk to in the process. So why didn't you mention the lawyers? In this case, it was the judges, the one that you find it harder to talk to. Well, because the lawyer didn't explain it properly, and the judges even worse. They explained it very badly. The lawyers, they wanted to just get rid of it, and that's it. Was it that everything was fast? Yes, everything was very, very fast. Sorry, I'm very nervous, Sarah. That's fine, you're doing great. Thank you.
They're just, again, confirming the findings that we had in our research. Regretfully, very often the lawyers are considered the ones who may be the only, so to say, saving line for defendants with intellectual and psychosocial disabilities, participating in processes. But exactly this is what we found. Very often they do not interact efficiently with their clients. Regretfully, they not always want to go visit them. Regretfully, the legal aid is only formal. So yeah, it's a very interesting finding. So maybe just the last question to Nicolas, unless he wants to tell us more. So, fair trial, what do you think, when do you think you had a fair trial after your procedural accommodations were provided?
¿Crees que has tenido un juicio?
So do you think you had a fair trial when you went to the court with a facilitator? Yes. Why? Because they explained everything properly and I knew what was happening and what wasn't happening. And
Thank you so much, Nicolas.
Muchas gracias.
Would you want to add anything?
¿Quieres añadir tú algo más?
No, no, no.
No, you're good. Okay.
No.
But you have the privilege always to interrupt any of us, you know, so if you want to at some point just
Siempre
let it
quieres
out.
interrumpir si quieres decir algo más en
Just
algún
do it.
momento. Puedes interrumpir si en algún momento quieres decir algo más.
Okay, all right.
No.
So, super, thank you. Sarah, for how long do you know Nicolas and how did you meet? This is my first question here on the list, so.
Pues a Nicolás le conozco desde que...
Well, I've known him since he got to the prison in Estemera because he was part of the specific module we've got there for people with intellectual disabilities, and that's when I met him 4 years ago already.
His needs for accommodations were identified. What were the circumstances and what happened after, please?
Bueno, pues...
Well, to get to know the support needs he had to face the trial, we had an interview to know how he communicated himself and to understand how he could understand what a process was, all the technical words. And according to that, and knowing him, and also knowing the people who had been working with him previously, like colleagues from other prisons, we were able to identify the support needs he had to face the trial. Once we gathered all that information and the interviews we had with him, we created a report. I was the one who made this report, proposing the accommodations that were needed so he could face the process with equal opportunities.
Sarah, could you share with us other experiences of providing facilitation to defendants within criminal proceedings? Maybe if there were other particularities that you can share, what other experience had you? And yeah, because this is actually, I think, quite new, at least from the perspective of the Enable project. This is quite progressive, and it's really interesting to hear how this develops in Spain. We really hope that our participants here and online as well will hear your inspiring experience, and Nicolas as well, and maybe we can replicate some of this. So maybe share a bit of your experience, and again, maybe you can share a few lessons learned. What would you advise to have as lesson learned? You know, what it's important to avoid, or maybe to carry out or implement by other countries that would like to go on the same path.
Well, first of all, and especially being able to identify which are the support needs throughout the whole process. So the moment the police starts working till the process is over with a verdict. And the sooner the accommodations start, the fairer the process is going to be, especially to make sure that that person is able to make informed decisions throughout the whole process. In terms of, to use the experience with Nicolas, that was very useful. In terms of accommodations, within the report, the procedural accommodations, including that it was very necessary that for all the operators to use simple and short sentences to adapt the speed of their speech, trying to avoid speaking too fast, especially. It was also necessary to inform that Nicolas had support needs to understand abstract concepts. So in case they had to be used, please provide examples. And we wanted to make sure that they were able to respect time, because in a very long process, sometimes, in this case, to make sure Nicholas had a sustained assistance throughout the whole process, so we could help him to, or stop as often as needed. We know that legal systems and processes are very fast, and everything is very strict. Timing is very strict, but being more flexible adapts in a fairer way the process, so they can everybody can access justice. And we also reflected in the report that to make it easier for them to understand, they shouldn't make questions that you could answer with a yes or no, but actually to ask for feedback and say, but not saying, did you understand, but rather, can you please summarize what you had just asked? So we could have more feedback. And something that's very, very important to take into account is to also have this support when the sentence handed out to this person, because especially in prison, you get the sentence days after. So you have something from the court and they hand out the sentence. And of course, this sentence, they aren't yet in an easy reading format, which is the next step, which is very, very needed. So having this support at that moment is very useful to support this person in a very stressful moment, because they're facing a crucial moment in their lives, because many things are going to depend on what is said there. So I think it is key to be able to start the moment the police starts working, and to be there as well at the end when the sentence is handed out to the defendant.
Super. Thank you so much, Sara. Of course, maybe if you could, in a few words, just mention what would be, and you already touched upon it a bit, what would be the next steps for the Spanish system of facilitators, like in a few words, and maybe as well, just something that maybe for us and maybe for the ones that are joining us online, what was the collaboration from your side with justice sector professionals, who were more cooperant and who were less, and yeah, well, if you want to say this, because maybe it might be a bit tricky, so yeah, we'll leave it up to you.
Well, I think that the first steps, as Sonny was saying, there's still a lot to do, and here with this piece of legislation, Law 8/2021, the role of the facilitator was born, but we have many legal operators and many police operators that still don't know about this role. And so it's very, very important to keep on training, train people basically, because especially in the police, they need this facilitator extremely fast. So I think this is a right that people with disabilities have, and when they read their rights, when they're arresting someone, just like they can have a translator if you speak a different language, or having someone to support them in communication if you're using sign language. I think it's also important to have, everybody should have the chance to have a facilitator. So this person can be there when they're reading their rights, and to have the facilitator at the first moment they start dealing with these persons. And first thing is to have it on paper, just like the fact that they can be assisted by a lawyer, or the fact that they can be assisted by a facilitator.
What an important conclusion. This is just a perfect conclusion that procedural accommodation is a basic human rights, right? Is a human rights that person needs to be provided in order to have access to justice, which is the paramount human rights. It's the way that people are receiving redress. So it is an obligation of states to provide it. So we are speaking about not privileges, but obligations. So thank you so much for this. Maybe we would want to switch to our speakers online if they can hear us Roxana, maybe? Superb. Roxana, I can see you, and hopefully I can hear you as well. I think you're still muted, or not? Or can you say something? Superb. Yes, we do hear you. Welcome, Roxana. We're really excited to have you in this panel. It's so fantastic to bring your insight as a judge and an international judge, as an expert in access to justice on these topics. Maybe I can try. Maybe we can go ahead with. Superb. Thank you. So, if you could please develop on your experience to provide procedural accommodations, or maybe the question would be, in your practical experience, do procedural accommodation matter, and why?
Ion, if I may suggest, if you have more questions for me, can you put them all together so I can address them all in one answer?
Absolutely, Roxana, absolutely. So the next one would be, if they are important procedural accommodations, why are their advancement in this field taking so long to occur? So why there is so hesitation to adopt legislation, and on the other hand, to put them in practice? And maybe the last question is, what do you think states' representatives should do to help these reforms move forward, please?
Thank you, Ion, for your questions. Hello to you all. First of all, procedural accommodations are fundamental to ensure that persons with disabilities use their rights effectively. We cannot talk about a fair trial without reasonable modifications to the standard procedures to ensure fair access to justice for everyone.
No sound.
Although the legislation has evolved lately, there are still certain practical obstacles preventing the defendant with disabilities to fully engage in judicial
I see
proceedings.
Roxana Komsa is talking, but we can't hear her. At least I can't.
We do hear Roxana.
Can
Roxana,
anyone hear me at all?
Here in the room, we hear you well. We hear you and see you well as well. Yeah. Roxana, could you please say a few things so we will do a test?
Shall I continue or resume from the beginning? Hello?
Yeah, just this.
Test.
Yeah, let's do a test. How about now? Are the participants online not able to hear Roxana?
No, we cannot hear.
Okay.
Josie.
Yeah.
I do.
Hello?
Yeah, I think you're back, Roxana. Superb. So
Can everyone hear me now, everybody?
we do, yeah. Could we ask you to repeat once more what you just shared for everyone to hear?
Of course.
Thank you.
So I was talking about the fundamental importance of procedural accommodations for defendants with disabilities in order to ensure fair access to justice.
Yeah, we hear you well. Yeah, thank you.
And although the legislation has evolved lately, there are still practical hurdles that prevent defendants with certain disabilities to fully engage in judicial proceedings. Sometimes the criminal justice actors lack the necessary expertise and they are not able to identify the nature of the defendant's impairment. Often, the criminal justice actors are overworked and deal with a heavy backlog of cases. They lack the extra time or energy required to properly support a defendant with disability?
Roxana, I think you can just go ahead. I think there's no need for pauses, right? I think we can.
Wait, all right. It's just that I hear the translation at the same time, but I will go ahead. Unfortunately, all these impediments come to the expense of the defendant and could amount to a lack of defense so serious that could constitute grounds for a retrial. Now, what can we do about it? Ion, you asked, what can the state representatives help this reform to move forward? And since I'm essentially a practitioner, I will start by asking, how can we, the criminal justice actors, help reform to move forward in the first place? As criminal justice actors, we must be proactive and use the tools available to us to support defendants with disabilities. How can we do this? I will illustrate this by a practical example. A case that comes from Kosovo, where I served as international judge. The person with disabilities in this case was an injured party, but the case is relevant equally for a defendant. On trial, there were serious sexual offenses. The injured party had a speech impairment and was deaf. Was also suffering from severe anxiety. We, the trial panel, started by evaluating her condition. We engaged in this process a psychologist, which we managed to get paid from the funds of Ministry of Justice. Based on the recommendation by the psychologist, we undertook the following measures. We assigned a sign language interpreter for the injured party. We allowed her sister to participate in the proceedings as a trusted and support person. We appointed an ex officio, a state lawyer, to assist her during the proceedings, and we insisted that they have regular and constant contact with the assistance of the sign interpreter. We accepted that the injured party takes part in the proceedings from a remote location where she declared she felt more comfortable than in the courtroom. And we simplified all the questions and communications in order to make the translation easier. And keep in mind that we had not only sign language interpretation, but also English-Albanian translation. We undertook these measures at the very beginning of the proceedings. This way, the injured party could give a statement, could examine witnesses, could make informed choices, and state her positions through her lawyer. We managed to communicate and engage with her in an effective and meaningful way. This is just an example of good practice, and I credit this success story to several factors. First of all, we as criminal justice actors, we were willing to invest extra time and effort. We listened to the specialists. We involved the injured party herself in the process. And lastly, cross-sector cooperation. Throughout the process, we cooperated tightly with all criminal justice actors involved. Therefore, it is in our power as criminal justice actors to choose between quick judicial proceedings and fair judicial proceedings. What will we choose? I hope that the bench book created by Validity will help us make this choice. And I will conclude by saying that ideally, the good practices outlined above should be coupled with measures at the state level, such as legislative change, policy making, securing human and financial resources for training, and building expertise in support of the defendants or parties with disabilities.
Thank you so much, Roxana. This was
Thank you.
This was so insightful. There are so many things that that you've mentioned that are as well replicated in the findings that we've identified in the enable research, but as well those type of I mean, when it comes to workload, excessive workload of judges, a lack of resources, lack of inter-institutional collaboration or multidisciplinary approach to identifying needs, but then as well about the mere availability of time, right, to be able to go thoroughly through the process. But as well, it's interesting that you found a very, I would say, international human rights law relevant instrument and approach to sorting out this specific situation. And this required a bit of creativity from your side as well, and a bit of understanding, and on the other hand, empathy too. Maybe we can go to give the floor to our next speaker, who is Carolina, and then maybe we will have questions for Roxana and Carolina. Yeah, so we welcome Carolina, if you can hear us.
Hi, Ian, I can hear you.
Superb. Welcome, Carolina. We are very excited to have the views of an international lawyer on this topic. So a few questions that we wanted to ask you is, do you think that procedural accommodations are important, and why the progress in this field takes so long? The other question is, given the delays in reform, do you think that criminal justice professionals can rely directly on international human rights law when providing procedural accommodation? And the final question is, if so, what mechanisms and practical tools are or should be in place to allow them to do so? I'm happy to go through the questions once more if needed, but thank you, the floor is yours.
Thanks a lot, Ian, and very happy to be here as well. So indeed, as we've already heard several times, procedural accommodations are crucial to allow for access to justice for an important group of persons in our society. So procedural accommodations are necessary to allow for fair trial and for equal access to justice for persons with disabilities. There is quite a rich body of international law that exists nowadays, and we've touched upon already some of these instruments this morning, but just perhaps to quickly go through them. We have, of course, the UN Convention on the Rights of Persons with Disabilities that has been very widely ratified. It has been ratified by all the EU member states and also by the EU itself. The convention established also the Committee on the Rights of Persons with Disabilities that monitors the implementation of the convention by state parties, issues regularly concluding observations on states that are party to the convention. The committee also adopted a number of general comments over the past years that serve as authoritative interpretation of the convention. And the optional protocol to the CRPD establishes a communications procedure under which the committee can also receive individual complaints about violations of rights of the CRPD and failures in executions of the obligations under the convention. So there is already quite a body of case law coming from the committee that further helps us interpret the convention. And states have the obligation to implement it and to follow the recommendation. One other source to mention, an important one, is are the international principles and guidelines on access to justice for persons with disabilities that was developed by the Special Rapporteur on Rights of Persons with Disabilities, which include very practical guidelines. It's a very practical tool to provide for equal access to justice to persons with disabilities. So overall, the international human rights standards oblige states to ensure fair trial, access to justice, equality, and non-discrimination through using reasonable and procedural accommodations. There is a specific provision in Article 12 of the UN CRPD saying that the authorities must create an actionable and enforceable right to receive the individually determined procedural accommodations, including support, necessary to enable persons with disabilities to participate effectively in all proceedings in any court, tribunal, or forum. Further, the principles that I mentioned, they also give specific examples. They oblige states to also allow for access to intermediaries or facilitators, provision of procedural adjustments and further modifications of the environment, communication support, and so on. And they also say that all accommodations must be put in place before the start of proceedings. So, of course, we also heard there's a lot of challenges instead in practice, even in states who have ratified the CRPD or are in principle obliged to follow these international human rights standards. So if there is no national legislation or rules to implement and bring into practice, then judges and other justice actors can rely on them directly. And it is also through this Enable project that we are working together with Validity and the national partners on the disability rights bench books. So we're working as the International Commission of Jurists. We're developing the model disability rights bench book, and national partners are working further on specific bench books for specific national systems that are developing further on these standards and provide really concrete tools to judges and other justice actors to work with in their daily practice. So, for instance, there is more specification on which training of the justice actors is needed, providing also information on the existing legal framework at both international and EU level, giving a bit more insight in the existing case law, which can provide a lot of insights and examples. The bench books are also first looking at the overview of current challenges, so especially what was already mentioned before, the question of legal capacity or denial of access to justice, for instance, through substitute decision-making. And we also put the procedural accommodations in the framework of other procedural safeguards that are necessary also to be provided, such as the right to information, right to access to a lawyer, to legal aid, further accessibility of court facilities, and so on. So the bench books are hopefully a useful, practical contribution to the process, where, of course, much more is needed, but these could be some useful pieces in the puzzle to improve access to justice for persons with disabilities.
Thank you so much, Carolina. Thank you as well for mentioning about our efforts within the Enable project to sort of bring those standards closer to the national legislation by interpreting how those standards, international human rights standards, including the soft law, would be applied in the national legislation through the lens of national obligations, but as well national procedural legislation. What do you think? Why do you think this is, of course, a very good tool, and this is what we are actually seeing, right, in the findings that we had in the Enable project, that many judges or many criminal justice professionals are already doing part of those processes, but this is not consistent, and this is not relying actually on necessarily on any type of guidance. But why do you think it's taking so long for national stakeholders to, I don't know, to move forward with these processes in order to have something more systemic solutions in place rather than what we have at this point?
Yeah, I mean, it's a good question, and I think it's probably a mix of different factors. I think to some extent we must say that probably there is also a lack of political will. It's a lack of seeing this as a priority for many countries, unfortunately, even though there are these international obligations. And that's with many rights of minorities we've seen in the past, that just really takes a lot of time, that it's actually acknowledged also at the level of the society. But of course, the governments have the most important role to play. The laws have to adapt it and change and adjust it. So that usually also helps to create this change at the level of the whole society, seeing that as, of course, important rights to be followed through. But I can imagine there are also a lot of the practical problems and difficulties that also Roxana has mentioned, like really courts being overwhelmed and just not often having the time, not having also the knowledge. There's definitely lack of training also on rights of persons with disabilities in the proceedings. So yeah, I would say it's probably a mix of different factors.
Thank you so much, Carolina. This is so insightful. We have a few minutes still to open a round of Q&A for, I think, Carolina and Roxana first, that are live, right, Natalia? And then as well, we will have questions for our panelists, for maybe. If you have any questions, this would be a great moment to address them. Just please mention who are you addressing the question. Superb. That's a good level of enthusiasm.
Stephen Allen from Validity. When I speak to lawyers who represent defendants, sometimes they tell me it is simpler if the person just accepts a mental health diagnosis and then they avoid going on trial. What's your response to this? Is this the right way to protect the interests of persons with intellectual and psychosocial disabilities? Or do we need to be confronting defense lawyers who are offering this path? Thank you.
Who is this question for, Stephen?
To all of our panelists. I don't have a strong direction.
So who wants to go first? That's a very good question that actually is leading us to the next panel. So we're trying to be relevant, and as well, Stephen just pointed us in that direction. Who wants to eventually answer first?
I can perhaps start and then hand over to colleagues. Yes, I think that's a very good question. And I think we do see that sometimes it may seem simpler maybe to the lawyers representing dependents with disabilities. But of course, if this is the case and the person accepts the mental health diagnosis and avoids going to trial, they're actually losing their ability to be an equal partner in the trial as anyone else. So they would really lose the ability for their own access to justice, to be able to influence the trial, to be able to make their own voice heard. So I think it is quite crucial to keep insisting on rather supportive decision making and making sure that that we really see that persons with disabilities have legal capacity, and then they have, of course, different needs and different procedural accommodations are needed for them to equally participate in the proceedings. But I think, yeah, also for their own understanding of the trial and what happened, and further for potentially also accepting the result, I think it's really important that they can be the actors of the trial in their own capacity as anybody else. Perhaps Roxana or others will have more to add.
I think, Carolina, you touched excellently about the main points. I think this advice by the lawyer should be really used as a last resort. The priority should be specialized support to help the defendant attain trial competency. and make informed decisions. I would just add that in practice, this advice by the lawyer would be an easy way out if we think that in general, if the defendant lacks resources, he will be represented by a lawyer appointed by the state. And the lawyer receives a one-time payment, no matter how often he gets in contact with the defendant and how much support and energy he invests in the trial. So this could be one of the reasons why he suggests that it's easier for the defendant to just be lack of capacity, competence. And on the other hand, this could be an opportunity to improve the legal services by adding extra fee to extra payment to the lawyers who deal with more difficult cases or more time-consuming cases, such as this.
Thank you so much, Roxana. I think we are already behind the time reserved. We have 2 questions, please. I think it was Marce and then you, sir. So do you want to? Yeah, super. Please mention who are you addressing the question to. Thank you.
Gracias. Hola, soy Marcela Tenorio.
Hi, I'm Marcela Tenorio. I'm a professor at Los Andes University in Chile, and I'm in charge of the Milenio Institute, a government initiative. Thanks to the speakers for their presentations, we have 2 doubts regarding the role of facilitator. The first is whether that a person can invoke the need for a facilitator. For example, in the case of Nicolas, who has had that experience and knows whether he, in a new case, in a new episode, whether he can request the facilitator himself, or does it necessarily have to come from the system, from one of those procedural adjustments? And the other question is whether the facilitator has, whether that role has any difference when it is in the adolescent criminal system. I'm asking that because we have 2 different systems now in Chile, and we wonder what could happen, whether that is different, the profile or the role. Thanks very much for your question. I'm going to start with the last question. The profile of the facilitator is the same, but when you work with minors, you are also requested to have some training specialized on minors. Facilitators have a training as such, but in order to work with minors, you have to have that extra training also in support to underage. And regarding the role of facilitator, it has to be requested by any of the parties in the procedure. It can be the person itself, the legal operators or support professionals that are working with the person and that know about the need. Anyone can ask for the role for the facilitator, so that the person with disability can face the proceeding in equal terms to others.
Thank you so much. Thank you so much, Sarah. Thank you so much, Marce, for your question. Could I ask you, sir, please to mention your question if you still want to address it, and then I think we can move to the next panel. Just a second, we'll get the microphone for you.
Bien, yo la pregunta es...
My question is, if someone with a disability who does not know exactly what is happening and what they are doing, and they are being forced to do something that they are not aware of, they are being deceived So, for example, sign here or say that, or that you have done this or that. And that person does not know that with that they are going against their own interests. In fact, they are accepting that they are guilty of something that they perhaps haven't done, so they are just getting all the charges on behalf of someone else. If that person is, what I mean is, if that person has a legal capacity that in some cases is legally impeded to make some decisions, or whether those decisions are fully informed. For example, in cases where they are asked to sign a document and they don't know what the content of the document is, you are perhaps providing cover for a crime or pleading guilty yourself. And in order to protect that person, how would that be organized against that crime that they are committing, but unknowingly, or at least they are not informed of the consequences? So a person that perhaps, if they were fully aware, they wouldn't be doing that. That person can have a legal problem. They can end up in jail, or what God knows what can happen to them because they are being deceived or they have been forced or coerced into doing something. So either that person says that they were forced or that they were deceived into doing that, or else they will. They should not be applied the penalty, at least, because you cannot say that you have stolen or killed or this property is owned by me. I don't know if I'm making myself clear. What can be the solution for that? Or what is the protection that exists for people with disability if we face such a crime, or, for example, impersonation, a crime with impersonation, or with new technologies, someone can steal your identity, and we can be subject to be deceived more easily compared to someone that does not have a disability. So if you are deceived, what happens? Of course, you have done that, but you didn't know the consequences, the legal consequences of that. So what is the protection that is offered to those people?
Much for your question.
I can take this.
I see Roxana. Yes, could you please answer?
Just to be brief, any procedural act, in order to be valid, it has to be done with valid consent. So an act could be without consent, where the party would not have the capacity to give a valid consent, is allowed and can be nullified. And if this is the case and this is proven, this is reason for reopening the proceedings. So this is basically the legal guarantee to protect the rights of this person.
Thank you so much, Roxana. I'm sorry, I think we're keeping the other panel 30 minutes already behind. It's really 30 minutes. So if we may, can we take it to the break? We specifically have, I think, 1.5 hours at least to discuss among ourselves different issues related to. So if this would be okay, just please remember your question, and we will have the break and then we'll discuss thoroughly. Because I'm afraid we are keeping the other panel members or speakers busy. Sir, are you satisfied with the question, with the answer? Are you okay in general, or we can discuss the detail in the break? Yeah, super. Thank you so much. Thank you. With a round of applause, please, for our speakers. This is fantastic. Thank you so much. Thank you so much. So. I think we will invite to the floor our next speakers. I think some of them are going to. Thank you.
Muchas gracias por compartirnos.
Thank you very much for sharing your experience with us. Now we go to the last roundtable where we are going to talk about how can we find ways forward for people with disability to have equal access to justice.
Join me. Now I feel better. So, should we start? Okay, so now I have my procedural accommodation in place here, as I've told Stephen that I'm alone on the stage. Okay, so let's start. Okay, I really feel wonderful to be here in this afternoon because this insanity defense is it's one of my favorite subjects, and we have all of these three fantastic guests, even if they are online. And I was thinking that maybe we should start with the idea of access to justice with Stephen. We will not speak only us today, but in order to introduce our guest speaker, I think we should start with the idea of the panel. And the insanity defense, as it is written in the agenda, it's directly linked to the access to justice. And of course, to procedural accommodation and to legal standing and, of course, legal capacity. And if we have to take into consideration at least, I don't know, 2 examples from our countries, and I will start with my home country, Romania. If we look at the fact that we still speak about medical confinement in psychiatric hospitals, and as we are seeing this right to what's the name of medical safety, and we are seeing this as maximum security. And if we are also looking at the Center for Legal Resources case on behalf of Valentin Câmpeanu, he died in a maximum security psychiatric hospital. And then if we are also looking at our Bulgarian neighbor country, where we are still discussing on the same idea that defendants don't have access to justice due to the fact that they have psychosocial or intellectual disability. And I will close before I will give the floor to our guest with the idea that if we are also looking at Romanian example now, with the execution of the European Court of Human Rights decisions regarding the access to justice and the rights of persons with psychosocial and intellectual disabilities, the fact that we still have these huge problems with access to justice of defendants with intellectual disabilities. And I think we have more than 10,000 people confined in psychiatric maximum security hospitals in Romania. And a couple of days ago with my colleague, she's here in the room, Cezara, we trained a number of staff from penitentiary from Romania, and we discussed a lot about the link between discrimination and disability. So we have three guests in this panel. I will start with Mr. Bob Fleischner. Hopefully I pronounce correctly. So I think it's good morning in US. Mr. Bob Fleischner retired after more than 45 years as a disability rights lawyer in the United States. Bob litigated disability law cases in US state and federal courts. His cases included challenges to guardianship, prison conditions, solitary confinement, juvenile justice, civil commitment, involuntary treatment, and to advance the right of people with disabilities to be free from institutionalization. He co-directed one of the first supported decision-making projects in the US. He has been active in the Access to Justice Knowledge Hub, an international gathering of disability advocates, working to conform legal systems to the mandates of the CRPD. Lexis has published 3 editions of his treatise on guardianship law, and he has written numerous law journal articles and book chapters about capacity, disability law, and guardianship. Bob graduated from law school in 1973 and has been on the faculties of a law school and a graduate school for social work. So I think we have a lot of learn from Bob, but I will start with our first question. Why insanity defenses are contrary to the CRPD?
Well, thank you. And it's morning here, early in the morning, not as early as it is in Mexico City where Diana is. The insanity defense is a controversial concept almost everywhere that it exists. And it exists almost everywhere in one form or another. It's fair to say that the insanity defense really in a state of chaos almost everywhere in the world. Proponents to the insanity defense say it's fundamentally important to the criminal justice system or the criminal legal system. Critics argue that it's discriminatory, results in lengthy psychiatric detention, and includes the possibility of involuntary treatment. Insanity defense has been argued and found by the Committee on the Rights of People with Disabilities to be contrary to the CRPD because it is capacity-based. And the CRPD is interpreted laws that are based on capacity, laws about like guardianship, incapacity to plead, incompetence to stand trial, and the insanity defense. The CRPD specifically, the insanity defense specifically violates the CRPD for a number of reasons, including that it's based on a medical model of disability. The role of psychiatrists and other clinicians is critical in determining if someone is not culpable for a crime because of their psychosocial or developmental disability. It violates the CRPD because it is contrary to the broad right of access guaranteed by the CRPD. It violates the CRPD because it violates the right for legal capacity, requiring that all people with disabilities enjoy legal capacity on the same basis as everybody else. It separates the legal system into two parts. One part for people with disabilities, for everybody else. If a person is found in most countries in which the insanity defense is either raised or becomes part of the case, the person, the defendant, is prohibited from or unable to prove their innocence, is prevented from confronting witnesses against them, is deprived of other defenses that are available to all other defendants, and is deprived of many procedural guarantees that are available to all other defendants. It creates this two-tiered legal system that's problematic and violates the CRPD. Finally, the common outcome for the insanity defense is usually indefinite institutionalization, either in a prison or a jail or a mental facility, often a forensic mental facility of some kind. And the term of confinement is usually indeterminate, certainly long, and it often is longer than it would be if the person had been found guilty of the crime for which they were charged. So, since the CRPD ensures the right to liberty on equal basis with everyone else, it does not permit people from being detained merely on the basis of their disability. And in all of these ways, the insanity defense violates the CRPD.
Thank you. We were also wondering if you have come across any cases in your practice that have consolidated this position that you already explained.
Well, most of the representation that I've done of people who were involved in cases in which the insanity defense was part of the case involved their commitment to mental hospitals after a finding of not guilty by reason of mental illness, as it's called in the state where I practice. And in those cases, my client, at that point the defendant, was at least was theoretically under the same standards that anyone else would be who was being civilly committed to an institution. But the fact is that the fact that they had been involved in a crime and had been found mentally ill during the commission of the act that would have been otherwise criminal meant that they were treated quite differently than everyone else who was subject to involuntary institutionalization. In the United States, there are several states that have abolished the insanity defense. I think there are 4 states out of the 50 that have abolished the insanity defense. In those cases, the defendant can argue that there was no intent, it's something that's called mens rea, and try to prove their innocence that way. But even if they're found innocent or found not guilty, they often are subject to long-term institutionalization in mental hospitals after a finding of innocence. So there's been very little integration of the CRPD's interpretation of the insanity defense in the United States, and I would say that that's true in many countries. Of course, the United States has not ratified the CRPD, but even in countries that have, it's the implementation of the abolition of the insanity defense is not something that's happening worldwide. It has happened in some, particularly in Sweden and a few other countries.
You mentioned that only 4 states abolished this measure. Why do you think states are hesitant to abolish it?
Well, I think, first of all, the abolition in the states in the United States is less driven by the kinds of things that we're talking about, equality and equal access to justice, than it is that in those states there was a feeling that people with psychosocial disabilities were getting away with something by using the insanity defense. So the reasons for the abolition here have less to do with the kinds of things that we care about and are articulated in the CRPD than they do with a feeling that we have to punish people and people with psychosocial disabilities are getting away with something. The other reason why I think abolition has been difficult around the world is that, as a friend of mine said, when we're trying to implement the kinds of things that, like abolition of guardianship or abolition of the insanity defense, we're really up against thousands of years of history in the legal systems. And we have to keep in mind that the other side has hundreds of years of a head start on us. And that makes it very difficult to achieve the kinds of things that the CRPD is looking to achieve.
Thank you so much. And I think we will also take questions at the end of the panel, if you can still remain with us.
I certainly will.
Thank you. Okay, we will now move to the next panelist. If I'm not wrong, is Ms. Patricia Cuenta. I think.
Hola, sí. ¿Me oís bien?
We have to see her.
Yes, can you hear me?
Great. Thank you. Thank you. I will first introduce Ms. Patricia Cuenta, and then we will also have some questions. So Ms. Patricia Cuenta Gomez is Professor of Philosophy of Law at the Carlos III University of Madrid and researcher at the Gregorio Peces Barba Human Rights Institute, of which she is also academic secretary. She is Deputy Vice Rector for Equality at the Carlos III University. One of her main lines of research is the right of persons with disabilities and the implementation of the CRPD in Spain. In this line, she has participated in numerous projects and is the author of several publications on accessibility, legal capacity, the right to vote, or the privation of liberty. On the latter, she has published a book on the issue of involuntary detention and has produced a report for the Spanish Committee of Representatives of Persons with Disabilities on the adaptation of Spanish prison regulations to the convention. So, welcome. Hope you can hear us.
Sí, oigo perfectamente.
Yes, I hear you loud and clear.
Okay. I will also put my translation on. I understand you will speak in Spanish, yes?
Sí.
Yes.
Thank you. From our research, we also learn about the so-called good models in Spain and Sweden. And as you are here in Spain, we were wondering if you can answer. We are starting with the first question. The insanity defense is handled differently here in Spain, as I mentioned already, in criminal proceedings than in many other jurisdictions. So why do you think Spain take a different approach in this respect?
Bueno.
Well, I think it is only partially different. I'm going to try to clarify what are the main differences and similarities. In Spain, the concept that we have to deviate those people that have a disability that supposedly are exempted from the ordinary proceeding is the role of inimputability, which is works to some extent as the insanity defense. So it means that the person has no capacity to be considered guilty criminally. So in the criminal code, we have some causes for inimputability, and some of them affect people with psychosocial and intellectual disability. They are exempt of criminal capacity if they cannot understand the criminality of a fact because they have an anomaly, or they use the word anomaly or psychic deficiency, or also to those that have affected the perception of reality due to alterations of the perception since they were born or from infancy. So it would work in a similar way to the other system. It is true that there is something which is different compared to other systems, which is that even though it is true that some years ago it was discussed in the procedural legislation a proposal to contemplate this figure, this concept, what we don't have in Spain is the lack of competence to be subject to trial, to stand trial. And that means that the person with an intellectual or psychosocial disability, even when they are going to be considered, even if at the end of the proceeding they are considered inimputable, they cannot be prosecuted, they are in the process. They are present in the process and they are part of the process. one thing is being there physically, and something different is that they are respected their right to access to justice. And that is something that has not happened in Spain, although in Spain there were some possibilities to do so, because there was an article in the criminal procedural law. There was an article that allowed for that, but they were not applied. Those adjustments were not applied in the procedure. And people with disability, even in proceedings where they were going to judge the inimputability, so disability had already been detected and they were going to be assessed in order to be considered whether they could be subject, could stand trial, they have not applied the necessary adjustment for that person to be able to participate fully. Of course, it is better to be there compared to not being there. But people with disabilities, even if they are not imputable, they have been in the process more as an object, more than a subject. They have been the object of the proceeding and not so much a subject, and they could not defend themselves. There are new elements, new reforms. It was criminal procedural law was reformed in 2023, and now there's an article that speaks about the obligation, not that it can be done, but there's an obligation to make adjustments in the proceeding and adaptations that, according to the law, they will have to do with understanding, with communication, and with the interaction with the environment. And so apart from the sign language and all that, they contemplate specifically the role of the facilitator, which is extremely important, and as has already been said, for people with intellectual and psychosocial disability, and also the possibility to be accompanied by someone else. And then the rest is more or less the same. The person with disability is present in the process. The proceeding can end with an imputability declaration, and that declaration, as happens in other countries, can have as a consequence the application of some special measures that are called safety measures in Spain, that we know that are not based on guiltiness of that person, because it is not guilty. They are focused on the dangerous character of the person. So they can deprive them of liberty or not. There's a non-custodial one, which would be the family custody, and then measures that have to do with medical treatment, for example, the application of a medical treatment, and among those that deprive them of liberty is institutionalization. In particular, in psychiatric centers, as the law says, and for psychosocial disability, and also the institutionalization in special education centers. That is the terminology of the law. That would be for people with intellectual disability. And that's more or less the configuration in Spain. That's our system and how it works. If I had to say, to give you my opinion, I don't think it is perfect. Of course, there are some aspects that can be better than other systems, but it also has many issues regarding the compliance with the CRPD.
Yes, totally agree. You already mentioned some of the elements that are in line with the CRPD, but can you please underline again, because it's linked to the efficiency of the access to justice. I recall that you mentioned in the beginning of your presentation that the person with psychosocial disabilities was physically present in the process, but the problem was with procedural accommodation, and you mentioned facilitators. Can you please underline again the main elements that are in line with the CRPD from your legislation?
Well, I believe, as far as I recall, when we were submitted the proposal for a reform, where there was an article where they contemplated that lack of competence to be in a court trial. We discussed that with Fermi and with some other people, and it didn't make sense to us. They should not be separated from the process. We needed to adapt the proceeding so that the person can be there with all guarantees and all protections. And sometimes those guarantees will have to be very intense. Of course, it is better to be there compared to not being, but being as an object is not significant improvement, really. or a substantial improvement. So that's why I think that we still have a long way to go. We have made progress, and we are at a very important moment in time because we are discussing how to implement those adjustments in some of the jurisdictional areas, not just the criminal law, and also the introduction of the role of the facilitators. And there's a group of experts that are going to start working on that. But I think that we are still starting with that. And then also, if I look at the safety measures, what they call those special measures that are applied to people with intellectual or psychosocial disability that are considered inimputable or unimputable, it is true that the Spanish legislation in force has some things that are better if I think about other legislations that are also applied. For example, in Spain, the adoption of safety measures is not mandatory, it's discretionary. So it can happen that someone with a psychosocial or intellectual disability is considered unimputable, and they are not going to be considered dangerous directly. There has to be an assessment whether that person in that specific case can relapse, can commit new crimes, and only if they consider that that probability exists would they apply those safety measures. So there could be no measure at all applied. So two things have to happen. They have to commit a crime, that you have to provide evidence about that, and then you also have to think that there's a probability that according to the circumstances of the person and not the fact, that we derive a future probability of the commission of new crimes. And only if those two concur, they would apply that measure. But there could be the case where they are considered unimputable, they have committed that crime, but no measure is applied at all, or at least no safety measure at all in the sense of the criminal system. There in Spain, there are clear limits regarding the duration of that measure, because we have proportionality principle. We can only deprive that person of liberty if the crime, in the case that they would be imputable, they would be awarded a penalty that is a deprivation of liberty. And you cannot, of course, impose a measure that lasts more than the penalty that they would have been imposed is if they were imputable. And I know that this exists in other countries. And they are also reviewed in time, periodically. And when they are reviewed, they can be kept, or they can be suspended, or they can be replaced for other measures. They can be replaced for other measures. And although it is true that the legal regulation in Spain is quite concise, they don't give much importance to the topic, but it seems that it could be possible, and there are rules now that speak about that possibility, that they could be served, those measures could be served in extra penitentiary centers. So, for example, in a hospital environment, and we consider that this should be given priority because it has more possibilities to provide rehabilitation and inclusion in society. But the problem, and I don't know whether you are going to ask me this, whether this is a problem regarding the perspective of the convention, and it really has a lot to do with that in practice. What happens in practice is that in many occasions the declaration of unimputability and the applications of safety measures normally lead to a deprivation of liberty because of the disability itself, and then it lasts longer than the sentence or than the conviction, and it is normally imposed, and they are sent to ordinary institutions. And why? Because it is a way in which the concept of a dangerous person works. They are considered dangerous almost directly, without any assessment. And what I said before, that there is no need to apply those measures, they become mandatory because everyone imposes them because of those medical criteria, as Bob was saying. They end up considering that the person is dangerous. In the end, deprivation of liberty is normally served in ordinary penitentiary institutions. So why is that? because in Spain we seem to provide a priority to those extra penitentiary centers like hospital institutions or so on. But those resources in practice are very scarce. There are very few, and the professionals in the criminal system do not know about them. They are very reluctant to accept. If you have a person with an intellectual disability, they are very reluctant to accept those people in normal institutions. Sometimes you have to have bureaucratic requirements like a degree of dependence or disability in order to be granted a measure. And then the law speaks about special centers, but those special centers are also very scarce. In Spain, there are only two penitentiary psychiatric hospitals and one penitentiary psychiatric unit, and those special centers that the law talks about have not been created. And what has been done is to turn modules in an ordinary penitentiary institution into special modules for people with disability that are imputable or unimputable, both. They are all serving sentence or measures there. And besides, there are times when even courts consider that instead of sending someone to a special center hundreds of kilometers from home, it is better to send them to an ordinary prison which is closer to their home to preserve their link with their family. The maximum limit is that conviction, abstract conviction, there are no mitigating conditions, so in the end the maximum limit becomes the real limit, and then there are no penitentiary benefits applied. And then the regime that they are subject to in those institutions have greater restrictions in terms of visits, in permits to go out, and the location and the situation of psychiatric hospitals in Spain is very concerning for us. It's really problematic. So for us, it is even worse to be sent to be declared unimputable and to be applied a safety measure. For us, sometimes it is even worse. It would have been better that you were declared responsible and imputable. That's my opinion.
Thank you so much. I think we learned a lot from this intervention, and my mind also ran to the idea of the European Committee on the Prevention of Torture reports from 2 years ago from Romania on penitentiary, when they underlined the fact that the population with intellectual disabilities and with psychosocial disabilities were harassed and abused, and the fact that there were no access to mental health services, and also the fact that when we are looking at forensic safety measures, hospitals in Romania, there is this discussion on, because also Patricia mentioned revaluation, at periodically revaluation. We also have this in our legal system, but the problem is that the population with intellectual disabilities cannot pass the minimum requirements to get out from the penitentiary. And I think now we can move to our third guest panelist, is Miss Diana Scheinbaum. If she's still there, it's midnight in Mexico. I don't know how we should say good evening, no? I will start with the introduction, and then we will start with questions.
Está amaneciendo por aquí, así que...
It's morning.
Diana is founding partner and coordinator of Documenta's Disability and Justice Program, which aims to work towards an inclusive justice system that respects the rights of persons with disabilities, specifically by recognizing their legal capacity and promoting their access to justice on equal terms with others. To this end, Diana promoted the creation of a program of justice facilitators to implement procedural adjustments in judicial process involving persons with disabilities. To date, the justice facilitators have participated in more than 6,000 requests for intervention by the Superior Court of Justice of Mexico City. Documenta also provided legal representation before the Committee on the Rights of Persons with Disabilities for Arturo Medina Vela, a very well-known case. The first case decided by the Committee on the Rights of Persons with Disabilities concerning Mexico, in which the international responsibility of the state was determined. Thank you for joining us. I will follow up on what the previous guests also discussed here with us today, and I would like to start with the first question. Why do you think states are so hesitant to abolish the insanity defense?
Well, thank you very much for the invitation. It is a pleasure to be here with you, with Bob and Patricia. I would like to start by telling you that the answers that I'm going to give you today and the ideas I would like to share with you stem from the fact that I'm part of a human rights and civil society association that in the last 12 years has had frequent and close interactions with the criminal justice system, as was said in the introduction, representing cases of people with disabilities, but also implementing a project for procedural adjustments. And from those interactions with the jurisdictional and penitentiary and health authorities, we have gathered some conclusions and some ideas. From my point of view, that resistance or that reluctance to reform the system and challenge the insanity defense has to do with the lack of knowledge on the part of the government. When we implemented that program of justice facilitators in the City of Mexico in 2017, so 10 years after the convention, the criminal judges were asking us about what was that convention. They didn't know what the convention was. And they have a huge lack of knowledge about the obligations and how international treaties demand modifications and amendments, not just in the legislative area, but also in the jurisdictional practice. And that tells us a lot about the crisis of the universal system of human rights and to what extent the justice operators incorporate in their practice the international standards on human rights. Another important factor that I consider important and that creates reluctance has to do with something that has already been discussed, the deeply rooted historical misconceptions about the people with disability and an impossibility to transition towards a human rights approach. The notion of protection, as Patricia was saying, those inverted commas, and the institutionalization logic or dynamics are so rooted in our legislation and in our own practice that it makes it almost impossible to provide visibility to the damaging effects of concepts such as insanity or unimputability. Why don't we make them all unimputable, and why do not they pretend that they have a disability? But we have to speak about the effects in practice. Patricia has said it quite clearly. They are excluded from criminal responsibility. They don't have any support in the proceeding, and then they end up being deprived of liberty due to their disability, and even for a longer time, or even in conditions that are much worse than those people without a disability. So I think that like the interdiction and the non-consensual deprivation of liberty seems to be done in favor of the people with disabilities, but that is not the case. That is what we have to challenge, the main thing that we have to challenge. Another factor is the absence of incentives to explore different alternatives. If we think about a judge or a criminal judge that has been 30 years practicing, and they were taught at university that you have to protect people with disability, and that means appointing a guardian or impose some measures. That is what they have learned. What could lead that judge to question and challenge what has always worked for them? And I remember about civil and criminal judges that would tell you this is the best alternative for people with disabilities. So we have to get to know the system inside out and how to generate incentives to promote change. From civil society, what we have learned is that sometimes it is necessary to put push the system into a crisis so that we can promote change. In the case of judges, it is extremely important really to understand that sometimes the risk of their resolutions being reviewed by superior courts could lead to a change in their practice. And also the same for state institutions, and also the public denunciation could be the mechanism to promote a deep change.
I think you already started to respond to our second question. What is the way forward for the reform?
Yes, I think that the situation of people with disability or intellectual or psychosocial, those that are declared unimputable and those that are not declared unimputable but are in prison anyway or in a psychiatric institution, you realize that the reform goes beyond an amendment in the criminal legislation, either procedural or substantive, or the laws that regulate the penitentiary administration. It affects several areas of the state, and we should focus on a structural reform. At least I would like to give just a few notes that for me are very relevant. The need to invest in the root causes. People with disability that are faced with the criminal system or the penitentiary system share exclusion and marginalization paths that place them in greater risk to end up facing the criminal justice system. And at least in Latin America, we have a dramatic situation that sometimes people in the penitentiary institutions have access to services that they don't have outside. And within that deep reform, we have to intervene to guarantee the right quality of life and social protection that is sufficient. And that's why we insist on core responsibility of the institutions of the state. The reform requires the intervention of institutions regarding access to social services, to health services, to housing, to labor opportunities. If we don't act on the causes, we won't have an impact on the lives of people with disability. And we run the risk of not catering for a situation of exclusion. In Mexico, as I was telling you, we have been implementing this justice facilitator project for 6 years, as I said, and we've seen a change on how criminal proceedings have been adapted. People that are there that are taking part together with a facilitator understand the scope of the proceeding, they can present evidence, and they understand everything. But we haven't prevented them from going to jail, and they face terrible situations there, and when they get out of prison, they don't have access to any program, and they go back to that penitentiary system again. So there's no doubt that the implementation of procedural adjustments is necessary and urgent, but it is not enough. And the reform has to go to focus on that as well. And on the other hand, the reform should invest on the solution of social conflicts, acknowledging the failure of the penitentiary system as a device that promotes rehabilitation and reintroduction into society. Not only Mexican prisons, I guess that the Spanish ones, penitentiary systems, we have realized that they are not the right environment, the ideal environment for rehabilitation and for reintroduction into society. And so we have to challenge the whole criminal system and alternative mechanisms for conflict resolution that focus on restoring or reestablishing that damage. And we have to bet on regenerative justice. And in the specific field of the criminal justice and criminal law, there is an urgent amendment or reform that has to be substantive in nature. It is necessary, at least regarding the unimputability. We have to acknowledge that disability is not the only condition whereby a person can be prevented from understanding an illegal act or acting consequently. And unimputability affects people with disabilities more than any other. So we have to be able to make unimputability be a neutral figure and guarantee that people with disabilities that are accused, that they have access to the same rights to defense or to exclusions of criminal imputability, like self-defense or whatever. At least in Mexico, when we identify disability, we resort directly to this insanity defense, and they waive other measures that could be less discriminatory. And I think that someone who is accused, if they don't understand the illegal character of their behavior, they should be treated equally as any other accused person that doesn't have that understanding or that knowledge, and not necessarily resort to those safety measures that have been defined specifically for people with disabilities. In Mexico, we have a treatment for unimputable people, which in the end is just a detention based on the disability itself. And there, I think that there are opportunities for improvement which are quite relevant.
Thank you so much. I think we can, thank you so much, Diana. I think we can now move to questions, to have questions from our participants, yes. And I will also want to add something that, and underline again something that Diana and also our panelists mentioned, these root causes of what we are seeing in, I mean, all over the world in this moment regarding insanity and security measures. The fact that most of these people have to go back to the penitentiary system because there are no services within the community. And sometimes they get more within the penitentiary. And this also reminds me of a call that we received a year ago at the Center for Legal Resources from a social worker from a penitentiary from Romania. She called us and she told us, look, I have this man at the main gate. I need to free him. He has an intellectual disability. He used to be institutionalized and he's for the second term here. And there is no way for him to get housing or social services. Could you please help us? And I think this is also linked to what Diana mentioned, the fact that sometimes they get more services within the penitentiary. But I think here the good, I don't know how can I say, the good point here might be the fact that this man was almost freed from the penitentiary system, because if this man would be admitted in a forensic or maximum security psychiatric hospital, then he will remain there till he will die probably, because there will be no success story for him at the end. So we should start with the question from the, I think we have one question there. We might need the microphone.
Hola, ¿se me escucha así? Buenas tardes, mi nombre es...
Good afternoon. Violeta Purano. I'm a lawyer in Chile, and I'm working in the Carlos III University in Madrid. Patricia is my tutor. What I wanted to ask is, why can there be a neutral definition of unimputability or insanity defense, so that those people feel represented by it? Could we establish a neutral framework, just taking out the psychiatric premises? How could you make that compatible with the excessive participation that the psychiatrist and the medical authority have in the declaration of insanity defense, so that those people are not the only ones represented there? That on the one hand. And so in the end, the question is, how can we conceive an imputability under a neutral perspective? And then, on the other hand, how to reconcile or how to reach jurists, the criminal lawyers, regarding those topics. If we look at interdiction and we look at in the civil law, it is normally related to accepting different modality, which is not the replacement of the will of people, but considering their will. And we know a little bit more about that because there have been reforms at global level about interdiction. But in the criminal system, there is some reluctance. And as Diana was saying, there is a lack of understanding and an extraordinary justification of insanity defense as a mechanism for protection. So what could be the strategies that we could devise to reach the jurists and the criminal lawyers and those legal operators that don't have much knowledge about human rights and end up being the ones that apply those rights? Thank you.
Thank you. We should turn the question to our panelists, or if there is anyone from our guests.
Can I just make a note that we are around 30 minutes already behind the agenda? If there are any other questions, can we bring them to the lunch? So, yeah, please. Who was this question for? Who were you addressing the question? Do you have some? All right, superb. And maybe after that we can go have lunch. Thank you.
Okay. So do we have anyone on the Zoom? Do we still have our guests there, or should we answer?
There is silence.
No sé si
okay, no, there is someone.
Intervenir en el orden o no sé cómo queréis.
I'm here. I don't know if you want me to speak.
Bueno,
of course, it's very difficult to define the situation. In Spain, we already have a cause of unimputability that is applied to people that have addiction problems, of drug addiction, for example, and they speak about the fact that they don't understand the illegal character of their actions. But of course, when we want to define it neutrally, we have to be also very careful, because it is not so neutral. We have to look at whether it is a disproportionate application. There are several things. If insanity defense has to deal with mental ability or with cognitive capacity, it will be applied more. Of course, we have to open it up. It have to be made more neutral. But if it has to be applied to people with disability, it will have to be combined with the fact that it is not a prejudice for them. It cannot damage them. How are you going to treat worse a person that cannot be considered guilty compared to someone that can be considered guilty? And also problems with reintroduction in society, rehabilitation. They end up saying that the person was there because they were dangerous and they didn't know what they were doing, but they were dangerous. And that's a label that you will carry around forever. And of course, we have to have neutral definitions, but that also has to be combined with responses that are proportionate, that have to be different for people with and without disability that commit a crime, being unaware of it, or they cannot act otherwise. They can be people with or without disability, and then to have a better response. And then regarding how to convince the criminal experts, the same that we have done with the civil lawyers. We have to raise awareness, we have to train, we have to educate, and then introducing the reforms and trying to count on those people that are experts. And we have more and more people from the criminal law area, as we did with the civil law. We thought that there would not be any reforms for Article 12, and they are not the best ones, but at least they are there, and we didn't think they were possible. I would like to add something, if it is possible. This topic of neutrality of the insanity defense, I think that the fact that you live in a country where there can be, for example, a wide indigenous population has also led us to understand that the capacity to understand whether something is illegal has to do with power and privilege. We understood in Latin America that there are cases of indigenous population that don't speak Spanish, that have never gone to school, and suddenly someone comes to them and they say, can you take this bag from here to there? And they end up being accused of drug trafficking at international level. This is a case that was submitted to amicus curiae, and it was solved. But there are other situations that have to be defined, and which are not determined by the disability of the person, but by their situation and how that situation prevented them from knowing that that behavior was illegal. It is interesting because, for example, in Colombia's criminal code, insanity defense includes those situations of immaturity or socio-cultural problems. So that's what I mean when we speak about the fact that insanity defense should not have a negative impact on the people with disability, and not to just allocate it to people with disability. It is not only the people with disability that sometimes are not able to understand the illegal character of something. There are many other people.
Final question.
I'd like to make a brief comment too on
yes, please.
Particularly regarding the role of lawyers. I think that for many attorneys, the dilemma in representing someone with a disability in a criminal case is that the options are either prison or a forensic institution. And being a person with a disability in a prison is not a good place to be. It's also true that being in a forensic facility is not a good place to be. But from the viewpoint of most lawyers, and in fact from many defendants, they'd rather be in a allegedly non-punitive environment in a forensic facility than in a prison. So until there are alternatives to institutionalization through community programs and other alternatives available to people, the stark reality for many defendants is a choice between prison on one hand and an institution on another. And even the best lawyers who really understand the disability system and really work well with people with disabilities are stuck because the alternatives are terrible no matter what they are. And in many cases, the alternative of a mental health facility is a better alternative than a high security prison. And so until we're not going to be able to convince lawyers about the things we believe in until we have something different to offer them and offer their clients.
Thank you. Can we take one more question?
There is like a kind request for another super brief question to Patricia, a lady in the room, please.
Yes, my question was for Patricia. In this question that is presented by Diana, making the penitentiary and the criminal system more uncomfortable, can you come up with some path while we wait for future reforms to prevent the situation of people with disability from being the one that it is. We have to understand that there are other social values that can make it difficult to be institutionalized or imprisoned. How can we prevent this, the situation of these people to start with? I'm not just talking about the fact that they are in prison and they are not in a specific module. Sometimes people with lots of difficulties to adapt to the penitentiary regime are not in those special modules, but they are in very severe isolation prisons, and that they stay there for a long period of time, and they can then get into trouble, and they can be aggressions to other colleagues, to other penitentiary officers. So that is succeeded in time with new convictions and with new penalties. I'm Ana Gordaliza, I work in the prison system, and I'm a member of SAMPAE, which is a working group that has an interest in mental health of the inmate population. And we are very much interested on this topic. Yes, I think that the legal reforms are necessary. As I said, we published a report about how to change the whole system and the penitentiary regulation to prevent situations such as the one you described, but I realized that a person does not necessarily have to go to first degree. They can go directly to some other degree of imprisonment. In Spain, with the current legislation, penitentiary legislation, there can be many different devices that allow you to deviate someone for whom prison is an added suffering. There are ways to deviate them from that path, but they don't work, and that is normally due to the stigma that those people carry because of the fact that they are dangerous. They are disabled, they committed a crime, and they are dangerous, and that's it. And everything is part of one pack. And sometimes it is just a question of poverty, but they have that stigma of being dangerous and also the stigma of disability. So there are real possibilities of doing that in the system, but they don't work. And sometimes it is because of the stigma that also has to do with the training of the professionals that work in the system. And that does not only happen to unimputable people. We also have to change the response that we give to the imputable people. In Spain's deprivation of liberty, we have fewer crimes than any country, and we have more inmate population than many countries. So that's what Bob was saying, the regenerative justice, other social measures that could help us not have to choose prisons always. And for people with disabilities, prisons are sometimes very hostile place, more hostile than for the rest of the people. And we see people that relapse once they are in prison, or they don't access benefits because they don't have a social network around them. And also the third sector could play an important role there when it comes to offering them that network so that they can access some other way to serve the sentence or the measure. The reform is, of course, necessary, but there are other things that could be changed with just a social buffer, so to speak.
Thank you so much, Patricia. Thank you so much, dear panel speakers. Thank you so much, Georgiana, for moderating. Thank you, Stephen. Thank you, everyone. I think we will give the floor to Jorda to close the formal part of the event, and then maybe I will make two small announcements, admin ones, please.
Thanks, everyone. Throughout this morning, we've been able to see that the rights of people with disabilities continue to be violated in many countries in the world. But we have also seen that there is hope for us. If you have the necessary support, you have a great part. You have achieved a great part. And I was able to understand everything when a technician helped me understand. And I started to take part in the program, delivering training to different legal professionals about access to justice. It is important that people get to know the experience of what we have suffered firsthand, so that that doesn't happen anymore, so that people with disabilities can go through a proceeding in equal terms as any other person. The simple fact that someone has a disability should not be should not lead to a different way of judging them. Thank you very much for attending and for participating this morning. We hope that you have enjoyed and that you have gotten some food for thought. I hope that there are many other spaces where we can share our experiences and fight for our rights. I turn the floor over to John so that he can close the event and tell us about the last details.
Stephen is insisting for... Okay. But in this case, I would like to kindly invite Natalia here as well. Please, 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 please. Otherwise, I'm going down. On behalf of organizers, we would like to, as well as Jordan mentioned, thank everyone for participating, all the speakers, all the participants. We know that we have participants at least from 3 continents. Some even traveled a long way to come here, so we are really, really grateful. And I would like to say thank you much to Natalia and the team of Plena Inclusión Incorpore for helping to organize this event. So Natalia, just maybe 2 words. I will just technical thing. Please don't forget the devices to return where you took them. If you have not registered for the event, please do so. There is a table right there at the entrance. And after the event, we'll share a link with the survey. Please, if you can spend 3 minutes on the survey, we'll be super grateful. Natalia, two words for you. I know you're feeling uncomfortable, but it's really, we're so grateful to you. If you want to say just 2 words.
Nada, muchísimas gracias a todos por venir, a los que habéis venido en persona.
Well, thank you very much to all the attendees, both in person and online. And just to close, we are now going to have a social event. We have a cocktail waiting just around the corner. Thank you.